guests, colleagues, and partners. I am happy to welcome you all to the 9th Sarajevo Arbitration Day on behalf of the Association Arbitral. First of all, I would like to thank our partners and sponsors for supporting the conference. GIZ, CLDP, law firms, Baker & McKenzie, Knotzel, Legal Solutions, Nick Kapper, and Schronher. May I thank to each of our speakers for taking part in this event. The quality and caliber of speakers this year is outstanding. The theme of this year's conference is Making International Arbitration for the Future. Balkans, so as Bosnia and Herzegovina, is at the crossroads, facing some very challenging and consequential questions. Should Western Balkans countries withdraw from the Energy Charter Treaty? How to avoid the Spanish scenario in the energy transition? And are the arbitration practitioners and institutions ready for the fast-changing world? I hope you will enjoy the conference. And now I would like to give the floor to our colleague, Ayla Srdarević, to announce highlights from the first year of GEM, developed and implemented by the Association Arbitral. Ayla, please.
Thank you, Anna. Hello, ladies and gentlemen. My name is Ayla Srdarević, and I'm very happy to announce that the project that we launched from the last Sarajevo Arbitration Day, which is the GEM project, which is short for Girl Empowerment and Mentorship Program, is a successful program that has showed how really the bond between a mentor and mentee is something that should be established and cherished as such. The GEM program is the first diversity initiative in the field of international arbitration, launched by Association Arbitral and supported by Arbitral Women. GEM aims to open doors and lift barriers to facilitate the entry into the international arbitration market for students and young practitioners by connecting them with experienced mentors from practice and academia. So here now are the list of our mentors and mentees, as you can see, and we the association worked very hard to really bring together the mentors that can bring the best from the mentees and to establish a sharing of experiences which the students from their perspective, when they shared their opinions of the GEM, told us that they are very happy with their work with their mentors. Now, following slide, we have our first, in the first corner, we have our first all-hands meeting, which, as you can see, was already interactive, showing that it was a constant sharing of experiences, of personal growth, of opinions about the international arbitration and the recent trends, and all the questions that the mentees had for their mentors and how to develop their skills were shared in all of these meetings. And in the next corner, you have the same meeting that took place. That was the second one. And we had also a third one, which was just a few weeks ago, where we had a catch-up of what the GEM has done so far, how the mentors and the mentees are feeling about the GEM, and we found that all the opinions were a positive feedback. On the next slide, we have some of our mentors, and as you can see by their affiliation, their experience and in practice and both academia and the mentees that they mentored really then shared their perspective that their mentors really showed a diverse knowledge, and also that they gave really good advice that I'm sure will be useful for their future. And here we have some of the quotes from our mentees. Some of these mentees are today in the audience, which I also want to applaud their coming to the Sarajevo Arbitration Day, and also the mentees that couldn't be today here, as well as the mentors, did share that they really are supporting both the GEM and the Sarajevo Arbitration Day, and that they look forward to the next conference, the 10th one next year. And here we have some of the in-person meetings that the mentors and mentees have. One of those pictures between me and my mentor, Armela, and we didn't color coordinate. That was by coincidence, but it really looked good on the picture as well. Yeah. And with this, we would like to say that we are thankful to our mentors and mentees for contributing to the GEM and for affirming the value of mentorship programs for the development of future leaders in international arbitration. Thank you. And with this, I would like to give the floor to Fahira Bradlia to announce our keynote. Thank you.
Good morning, ladies and gentlemen. It's lovely to see you again on this very special occasion. It's the highlight of the year for all of us, and we're very happy to see the event grow and to see some familiar faces recurring every year, which means there is some value that you recognize, and we appreciate that. Today, we are here gathered to speak about international arbitration. And that's obvious from the title, but it's not always obvious why it's important. And many countries around the world have questioned the legitimacy, the value, the importance of international arbitration. Even until recently, there have been some who questioned its legitimacy or whether it is still adequate for the modern world, whether it's an extraordinary dispute resolution mechanism or is it something that should be accepted and used as a progressive tool. Today, when we are looking at scrutiny and increased questioning of its legitimacy by public entities, by civil society, even by some in the legal community, it is a pertinent moment to pause and reflect on the values that built up international arbitration and why it exists today. Over time in history, you will be surprised just how far it reaches back. And there have been historical cycles where it has been questioned, it has been shaken, and then reaffirmed its position as a strengthening tool for the rule of law. So today, we are very proud and happy to have with us the one and only Gary Bourne, who is the leading expert and the authority on international arbitration, who will share with us this historical trajectory of international arbitration and highlight the importance of its development in the field. And although Mr. Bourne is truly one of the people who does not need an introduction, I will still take a few minutes to state openly just who we have with us here today, so bear with me for a few moments. And this is definitely not doing him any justice whatsoever. So Gary Bourne is the chair of the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale, and Dorr. He has participated as counsel in more than 675 international arbitrations, including several of the largest arbitrations at the ICC and in ad hoc history. Has sat as arbitrator in more than 250 institutional and ad hoc arbitrations. Mr. Bourne is uniformly ranked as one of the leading practitioners in the field and is the only lawyer in the world to receive global starred status in Chambers rankings for international arbitration. Mr. Bourne heads the firm's 70-person international arbitration group, which is based in London and integrated in its New York, Washington, D.C., and Berlin offices. He has particular experience in joint venture, investor state, M&A, investment banking, and other financial services, project finance, energy, oil and gas, and many other fields. Mr. Bourne has published the leading treatise on international arbitration, international commercial arbitration, which we all know well from our students' days, and we still refer to this day, as well as international arbitration and forum selection agreements. And recently, he has published his first novel, The File, which is an action-packed spy thriller. Highly recommended. Mr. Bourne also teaches at leading law schools around the world, including Harvard, Stanford, the National University of Singapore, St. Gallen, and elsewhere. And without further ado, I will leave the floor to Mr. Bourne. Thank you.
Thank you so much for that. I think I was promised a clicker at some point, which would be useful. But while the clicker is coming, thanks to Arbitral Women, thanks to all of the various sponsors here for having hosted this event, and perhaps most importantly, thanks to all of you for coming. It's a beautiful day outside, at least it promises to be. I know you have many other things that you could do, but instead you chose to be here with me, and I appreciate that very much. Perhaps in the absence of a clicker, I can just look at the organizers to advance the slides. As we think, because today being the 9th Sarajevo Arbitration Day, addressing the future of arbitration, it's important, just going back a couple slides, to think about how we got here to the present and also to think about the past of arbitration, international arbitration, because as we all know, if we don't remember the past, we'll be condemned to relive it. And the past also, I think, not just the past here in Sarajevo, not just the past in Europe, not just the past in the developed world, but the past everywhere on the globe has very important lessons for arbitration, for international arbitration. You can ask me, the organizers can circulate to you if you're interested, soft copy of the slides. And you can ask me questions either in breaks or otherwise about what some of the images on the first slide indicate. They actually tie in pretty well with the theme of the 9th Sarajevo Arbitration Day. But I promised you the past, and the past of international arbitration actually goes back a very, very long way. This image has two things on it. It has the stele of the vultures, which is from present-day Iraq, and it is, so far as we can tell, the first international arbitration. It's the image on the left, and it reflects a border dispute between two Middle Eastern states, and rather than going to war about their border dispute, they arbitrated that dispute. They submitted their border dispute to a neighboring kingdom who put that stone as a marker of their boundary. The award on the right is the earliest arbitration award in history. It's an award in a case between Kili and Tulpanaya, and it concerned water rights in also modern-day Iraq. The award granted, I believe, 7 silver shekels to Tulpanaya and an ox. And it, in cuneiform tablet, records the very first international arbitration. In both those two arbitrations, importantly, the parties with a live dispute chose not to submit that dispute to a state. They chose not to submit it to an existing court. Rather, in each case, they chose to submit it to an arbitrator, somebody the two parties together chose to resolve their dispute. Moving forward about 2,000 years, because those first two images that we saw were from respectively 26 and 2400 BC, 4,500 years ago, indicating, evidencing how long-standing in the past arbitration has been. But moving forward 2,000 years to another part of Europe, classical Greek antiquity, these are two fragments from documents in ancient Greek times. One of the fragments is from a treaty between Athens and Sparta. That treaty, like literally hundreds of other treaties between Greek city-states, contained an arbitration clause. It submitted future disputes, in this case, I believe, about maintenance of a temple on some island to arbitration before arbitrators chosen by the parties. The fragment on the right doesn't concern state-to-state arbitration of the sort that the ancient Greek city-states undertook, but instead a comedy by Menander from 300 BC or so. The comedy was about how private parties, individuals like me and you, resolved their disputes. It was about arbitration of a marital dispute, dispute over whether a wife had been faithful to her husband or not. And the parties agreed to submit that dispute, just like they agreed to submit many types of commercial disputes in the ancient Greek times, to individuals, arbitrators that they had chosen rather than to state authorities. Moving forward yet again, and another 1,000 years or so, this is a treaty between the Swiss cantons and the Emperor of France from about 1200 AD. The good news is we're jumping ahead about 1,000 years each slide, so at some point we will arrive at the present and hopefully also, because that's the topic of the conference, the future. This treaty between essentially Switzerland and France also, unsurprisingly, contained an arbitration clause. In the event that the Swiss and the French couldn't reach agreement about their territorial boundaries and the other promises they made each other, they would submit that dispute to 5 arbitrators, not to 1 or to 3, but to 5. 2 chosen by each side, the Swiss and the French, and a 5th, a proud a proud man, or as we'd say today, a proud person, chosen by the 4 co-arbitrators. And the Swiss and the French chose that means of dispute resolution as opposed to the other types of dispute resolution that states typically engaged in at the time, sending soldiers off to war and the like. Moving forward, it wasn't just state-to-state disputes that were submitted to arbitration. We all know from the history of arbitration how important it was as a means of dispute resolution in medieval trade fairs, a picture of which you can see on the current slide. Merchants from faraway places came together at fairs and didn't particularly trust the local courts, which also, being overburdened, were slow and not particularly expert in the customs of merchants. And as a consequence, the merchants submitted their dispute, unsurprisingly, to individuals that they chose, often 1 or sometimes 3 arbitrators. And in fact, if we look at the next slide, this was well described in one of the classic legal texts from not quite the Middle Ages, I think we're to the Renaissance now, Gerard Malline's Lex Mercatoria. I unfortunately am not well positioned to be able to read that, so perhaps while I'm talking, you try to read this. It's important, and I'm going to come back to it, because Malline's, who thought deeply about arbitration, explained why it was that merchants preferred arbitration as a means to resolve their disputes. Part of the reasons were pragmatic reasons, sensible reasons that merchants would well understand: speed, expertise, knowledge of the customs of the merchants, lex mercatoria, and so forth. But also, and please do look at this on the slide, I can't particularly see it, he emphasized how arbitration was important as an expression of the merchant's free will. And he calls out free will there, a voluntary choice, party autonomy of the merchants, to resolve their disputes through arbitrators whom they had chosen. And that was an important aspect of why it was that arbitration was so important to the merchants of the day. They had a role in selecting those who would resolve their disputes. We'll come back to this theme in due course. Next slide, please. And to some extent, from my description so far, you might regard arbitration as a sort of European phenomenon. We focused on almost Europe, Iraq, and Greece, and Switzerland, and France, and the United Kingdom. But arbitration was a global phenomenon. It wasn't just something that extended back, from our perspective today, 4,500 years, or something that extended 1,000 kilometers or so around us, but all around the world. This is an image from the Ramayana, one of the sacred Hindu texts, and a great war there between the monkey god and others was resolved by way of, or at least sought to be resolved by way of arbitration and something closely related, mediation. As it happened in that occasion, I don't believe it succeeded, but the thought was important, and more importantly, the thought was reflected in reality, because in traditional subcontinental culture, society. Arbitration was used at a village level to resolve all manner of disputes, both before and after colonial times. Moving forward, this is, of course, Jerusalem, where both Islamic and also Jewish communities used arbitration to resolve their respective disputes. The Jewish community, starting from the Roman times when they felt not and were not welcome in Roman courts, used arbitration. The Talmud describes arbitration with the acronym ZABLA, meaning each chooses one, reflective, as we've already seen, of the mechanism for selecting arbitrators, and also importantly, the parties' right to participate in the selection of the tribunal that would ultimately resolve their disputes. The Jewish communities took that institution with them, retitled as the Bet Din, into their diaspora throughout Europe, and it continues to function today. It was, moving on to the next slide, not just Jewish communities, but also Muslim communities in the region that turned to arbitration. The Prophet Muhammad not only is described in the Quran as having arbitrated disputes between Islamic tribes, but also disputes between Jewish and Islamic tribes. But in addition, one of his first roles was to resolve disputes about the Kaaba, the Black Rock, as an arbitrator, someone chosen by the parties to resolve their dispute rather than having recourse to local courts. Next slide, please. And thus, staying outside of Europe and still looking to the New World, perhaps a little bit further afield, in the British colonies, arbitration also was used. This is one of the earliest evidences that I could find, just a little bit after Gerard Merlins wrote his Lex Mercatoria. It describes how a colonial court, before the United States was founded, referred parties to arbitration, a decision maker chosen by the parties to resolve their disputes. Next slide, please. And I won't take us in detail through this. I mentioned that you could talk to me in breaks or otherwise about some of the historical curiosities that I've collected for you. This is George Washington's will, the founder of the United States. In his will, and I won't read it out for you, you can see it just as easily, he hoped that those who inherited his estate would not fall to fighting with one another. But in the event that they did, he chose not to submit the disputes to the courts of the United States, including the Supreme Court, which in a sense he had founded, but rather to arbitrators, one chosen by each of the parties, two co-arbitrators, and the co-arbitrators selecting a third arbitrator. Moving forward just a bit, arbitration also being used to resolve disputes, again on a state-to-state basis. This is from the 1870s, the so-called Alabama arbitration. If any of you should be in Geneva, I urge you to go to the Hotel de Ville. It is the site of the so-called Alabama arbitration, which resolved a very significant dispute between the United Kingdom and the United States. It would almost have led to war, but instead the parties, with 5 arbitrators, 2 chosen by each party, the presiding arbitrator chosen by agreement between the parties, successfully resolved the so-called Alabama arbitration. The hearing room, as I mentioned, you can visit in Geneva. But again, arbitration being used throughout recorded history until almost the present to resolve all manner of disputes. Next slide, please. But although I have described a kind of golden summer, there were also clouds or hints of winter coming. This is an excerpt from a US court decision from the mid-20th century. We indeed are getting very close to the present. And it describes what the court calls a dark chapter in arbitration. And that chapter refers to things which happened in courts both in the United States but also elsewhere in Europe. Next slide, please. And this is an excerpt from one of the most distinguished American Supreme Court justices, but also legal writers, Joseph Story. I again can't particularly see this, but I remember what it says, and you can see it more importantly. Joseph Story, the author of this, described arbitration as a kind of rough justice. He said that arbitrators individuals chosen by the parties couldn't really be trusted to resolve disputes, both because they didn't have the authority to order disclosure in his mind. He didn't know about the IBA rules yet, I guess. And also because arbitrators couldn't be trusted the way, of course, courts could be trusted to resolve disputes by applying the law or principles of equity properly. And therefore, what Joseph's story said, and this was important because it would shape the present, what Joseph's story said was that arbitration agreements, yes, they were valid, but they could never be specifically enforced. Parties couldn't be referred to arbitration. Rather, if a party breached its promise to arbitrate a dispute and instead litigated it, what would happen is the court would decide whether or not there would be money damages for breach of the promise to arbitrate. Party wouldn't have to arbitrate, it could litigate, and the other party would be entitled to damages. What were the damages? According to Joseph's story, the damages were nothing or nominal, because the party who had to litigate instead of arbitrating wasn't suffering any loss. It was actually getting a benefit. It was being able to do something that was better than arbitration, and therefore there were no damages. Effectively, it made arbitration agreements unenforceable. Next slide. If you thought that was an American peculiarity, there are some such things. It wasn't. This is the Napoleonic Code of Civil Procedure, and in Article 1006, it provided that agreements to arbitrate would be valid if, but only if, they named the arbitrators and if they specifically described the dispute that would be referred to arbitration. Next slide. A decision of the Court of Cassation, coincidentally on almost exactly the same year that Joseph's story issued that decision we looked at a couple slides ago, a case called Prunier versus Allianz, where the issue was an arbitration agreement in an insurance policy between two French companies valid and enforceable? It provided that future disputes under the insurance policy would be submitted to arbitration. The Court of Cassation said, and you can see what it said in English, next slide please, on this slide, said that it wasn't valid. It wasn't valid because it didn't describe the future dispute, which, since it was in the future and hadn't arisen yet, couldn't be described. And it also didn't name the arbitrators. And therefore, taking Joseph's story one step better, the arbitration agreement wasn't only unenforceable or effectively unenforceable, it was, in fact, invalid. Next slide, please. And just to round out the historical overview before we get to the present, this is the 1933 Nazi National Socialist Reichsdirectives from Germany. And next slide. And what these Reichsdirectives on arbitration did was to provide that no National Socialist state entity could enter into agreements to arbitrate. And the reason for that, Nazi commentators explained, was because arbitration threatened the National Socialist conception of the state and its control over the instruments of justice. According to the National Socialist commentators, only decision makers chosen by the state, answerable to the state, could properly resolve disputes between state entities, and also, the commentators suggested, between private parties. The state, the National Socialist state, had to be responsible for everything, and individuals ought not to be permitted to submit their disputes either with each other or to state-owned entities to arbitration, which brings us, you'll be happy to know, to the present. This is, of course, an ICSID hearing, and moving on, emblematic of the present, we can look at how the international community reacted to Joseph's story, to the Court of Cassation, and to the National Socialists. This is the Geneva Protocol, which made arbitration agreements, both international arbitration agreements, both valid, but also enforceable, specifically enforceable by a provision to refer the parties to arbitration if they had concluded an international arbitration agreement. The next slide shows the Geneva Convention, 1927, building on the 1923 Geneva Protocol, doing for international arbitral awards what the protocol did for international arbitration agreements, namely making them enforceable subject to only narrow exceptions in all of the contracting parties to the convention. Those two instruments, the Geneva Protocol and the Geneva Convention, were then combined in a revolutionary new instrument, which we all know well today, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or as we know it better, the New York Convention, which did two things: made international arbitration agreements specifically enforceable, valid and enforceable, subject only to narrow limitations. That's Article 2. And in Articles 3, 4, and 5 doing the same thing for arbitral awards. At first, the convention was almost a dead letter. The first states to ratify it were Egypt, Syria, and Israel. Interesting bedfellows. But most of the rest of the world didn't pay much attention. That changed over time. This is the current, if we go back just one slide, please. This is the current map of the world with the contracting parties to the New York Convention, 172 at last count, including almost everybody. North Korea hasn't yet joined, but almost everybody else has. The convention, in a very real sense, is universal. It's been described correctly as the most successful private international law treaty in history. Next slide, please. And this one's actually really hard for me to see. The ICSID Convention from a few years later, which did for investment arbitration, if we go to the next slide, what the New York Convention did for international arbitration. In addition, though, the ICSID Convention created ICSID, the International Center for the Settlement of Investment Disputes. Next slide, please. And you can see its headquarters there, to administer in a professional capacity investment arbitrations. Next slide, please. Oh dear. And although at first ICSID was envisaged to deal with contractual investment disputes arising from investment contracts, it soon came to be used in bilateral investment treaties. This is the first bilateral investment treaty, most of which, not this one, but most of which contained arbitration agreements submitting future disputes between investors, foreign investors, and host states to arbitration. This is a bit between Germany and Pakistan from 1958, just around the same time as the New York Convention. Over time, looking at the next slide, states around the world, including in this region, concluded bilateral investment treaties which provided both substantive investment protection to investors, foreign investors, and also provided arbitration as a means to resolve those disputes. Next slide, please. And these various treaties were given effect. The New York Convention and others were given effect in national legislation, the UNCITRAL Model Law, 1985 and 2006, giving effect to the provisions of the New York Convention, but also providing a mechanism for regulating the arbitral process in the arbitral seat. Next slide, please. And the model law being adopted very widely, not quite as widely as the New York Convention around the world. National courts, on the next slide, giving robust effect to the convention. And in contrast to that dark chapter in legal history that we saw several slides ago, arbitration being actively embraced by national courts, not just in Europe, but also the New World. Next slide, please. Arbitral institutions, a bit like ICSID, which we saw being adopted around the world, including in this region. You can see some familiar logos there, I think. Next slide. And not just a legal framework being created for international arbitration, but parties using that legal framework. This is the caseload statistics of selected arbitral institutions and a steady growth in caseloads across both this region, but also across the world. Next slide, please. Parties using arbitration to resolve all manner of disputes, energy disputes, mining disputes, sale of goods disputes, intellectual property disputes. Next slide, please. And indeed, arbitration being used by both the world's largest companies, but also ordinary ma and pa entrepreneurs. Next slide. Arbitration being used to resolve new types of disputes. This is the, I think, hard to see, this is the Court of Arbitration for Sport in Lausanne, Switzerland, which historically sports disputes were not submitted to arbitration. The ancient Greeks, perhaps with their Olympics, might have done so, but we don't have evidence of it. What we do have evidence of, though, is today's Olympics being very difficult to be conducted in the manner in which they're conducted without arbitration, without expert international decision makers able in a very rapid fashion, sometimes in a matter of hours, to resolve disputes on the spot. And you can see evidence of the growth in caseloads there. Next slide, please. The same thing in intellectual property disputes. Historically, IP disputes often being non-arbitrable, but here, arbitral institution, the World Intellectual Property Organization, being organized specifically to resolve nothing but intellectual property disputes and doing a fair amount of business at that. Next slide, please. And ICSID, of course, with some 800 arbitral awards issued as of today, going from a caseload in the 1970s of less than a case a year to a quite significant caseload today. Almost a golden age of international arbitration. Next slide, please. And if you look at the business pages, indeed sometimes the front pages, arbitration being used to resolve not just routine disputes between merchants like Gerard Malines described, but some of the most important, some of the most significant commercial, but also state-to-state arbitrations that one can imagine. I'll need to step aside to look at this one. But just as there were ebbs and flows in the past, also in the present, this is a resolution of the Andean Commission in which, following a bit on the Calvo doctrine from Latin America, they resolved that arbitration shouldn't be used to resolve disputes between foreign investors and host states. At first, that type of resolution attracted very little attention. It didn't dissuade states in that region, but also all else around the world, everywhere else around the world, from concluding those 2,600 bilateral investment treaties that we saw. But moving on, it found fertile ground in law schools. This is the Osgood Declaration, where a number of law professors criticized investor-state arbitration on the grounds that it interfered with the regulatory space of host states and that disputes ought not between foreign investors and host states be submitted to arbitration, but instead left exclusively to the authority of local courts or local politicians. The Osgood Declaration also criticized investment arbitration on a variety of procedural grounds. Next slide, please. That found fertile ground as well, not just in law schools, but also in selected Latin American countries. Hugo Chavez railed quite visibly against investment arbitration, swearing that he would not comply with ICSID awards against Venezuela and threatening physical force should the awards attempt to be recognized and enforced. Next slide, please. Same view elsewhere in the world. Vladimir Putin, a bit more recently, we're almost to the future, a law requiring creatively that corporate disputes, broadly defined, could only be resolved by arbitration institutions approved by the Russian Federation. Not exactly Hugo Chavez's approach, but nonetheless the notion that only the state ultimately could control the resolution of disputes. Next slide, please. And it's not just that that was a Hugo Chavez, Vladimir Putin approach. This is Donald Trump during his campaign, and then on to the next slide, promising to take the United States out of NAFTA, which had a quite robust investor-state protection regime, including investor-state arbitration. Ultimately, he was partially successful. The United States, Mexico, Canada agreement, which replaced NAFTA, reducing the scope of investor-state arbitration. Again, Trump's idea was that, in the words of his trade advisor, Bob Lighthizer, the only arbitrator I trust is myself. And that put it a little bit more bluntly, but in a sense, that's exactly what Hugo Chavez and Vladimir Putin were saying, and what the National Socialists were also saying. We don't trust individuals to be able to decide who should resolve their disputes. The only arbitrators we trust is ourselves. Sadly, the European Court of Justice, and this is just before the Achmea and Kamstroy decisions, I'm taking a similar view, at least towards intra-EU bilateral investment treaties. Next slide, please. And since this is, I'm sure, familiar here in the region, we can skip over these sad recent events which made bilateral investment treaties between European Union member states, at least with respect to their arbitration provisions, are arguably unenforceable. Next slide, please. And if one thinks this was a dark chapter, a dark modern chapter confined to investor-state arbitration, that too isn't right, because here is Lord Thomas, the presiding legal authority in the United Kingdom, opining on international commercial arbitration. He saw it as a threat to the English common law. For those of us in code jurisdictions, civil law jurisdictions, such as Bosnia-Herzegovina, that might come as an unusual suggestion. We have a code to which we can look for legal authority. He, Lord Thomas, saw arbitration as threatening the common law because it supposedly took cases away from the courts by which they could articulate the law. He neglected to mention that, in fact, the caseloads were higher in the English courts than they had historically been. But nonetheless, further criticism of international arbitration. That brings us to the future. This is a local artist you all probably know better than I, but wondering about what the future will bring. And that, in a sense, brings us to finally what I'm supposed to talk about, not the past and the present, but the future. What will the future bring? What does the future hold for international arbitration? Do we need it? And being a lawyer, perhaps not a good lawyer, but a lawyer, I naturally look to legal authority for the answer to that particular question. And the best authority I could find on this is on the current slide, and it expresses what I think the right answer is in two parts. Let's look at these two parts. And I'd like to, there are two, I think, quite different thoughts that are combined together in that rather short paragraph. And I'd like to talk about each one of those two thoughts. Let's start first with the second half, if we could just go back. Yeah, the second half, the pragmatic goals, which we've already heard some reference to. Speed, efficiency, expedition, cost efficiency, expertise. Next slide, please. I sometimes refer to those as the 6 E's of arbitration. They are pragmatic benefits, values, advantages. Arbitration is, as compared to the alternatives, more expeditious, more expert, more efficient, more even-handed, more enforceable, and in today's modern era, more electronic than the alternatives. And let's look at why that is so. Arbitration is more expert for, if we could just look at the next couple slides. There we go. Arbitration is more expert for some of the reasons that we saw, and going back to that Talmudic expression, each chooses one. Precisely because the parties choose the decision maker after a dispute has arisen. It's not that arbitrators have any particular special gift or greater IQ or EQ than other decision makers. It's that they are chosen after a dispute arises by the parties. The parties know better than anyone else in the world what their dispute concerns. They have more incentive than anybody else in the world for their dispute to be resolved in an expert and also an efficient manner. And as a consequence, when the parties have a construction dispute in the Balkans, say a road dispute, they're able to choose arbitrators that actually know about construction disputes, actually know about the Balkans, actually, in many cases, know about road construction disputes. And in contrast, a national court, unfortunately, typically is a judge who has to decide all manner of disputes: tax disputes, administrative law disputes, constitutional law disputes, commercial disputes, insurance disputes, landlord-tenant disputes, and maybe once in her lifetime, a road construction dispute somewhere. And naturally, the expert decision makers chosen by the parties after a dispute arises will better understand, be better equipped to resolve that, if we could go back a couple slides, resolve that dispute. That expertise brings, and if we could go a couple slides, also brings efficiency goals. You don't need to educate the decision makers in the substance of the dispute. They are also, by virtue of institutional arbitration rules, if we could go back 2 slides, several slides, able to resolve disputes on a fast-track basis. Institutional arbitration rules, you can see the ICC rules here, providing for fast-track arbitration for smaller value disputes. Arbitral institutions of the sort that we've looked at, providing for expedited means of dispute resolution, including emergency arbitration. Next slide, please. And arbitral institutions around the world adopting that. And as we all know, expedition brings efficiencies, time is money, and therefore the arbitral process, particularly compared to multiple layers of appeal, possibly parallel proceedings in multiple different courts, provides efficiency benefits. Next slide, please. And the slide after that. Arbitration, international arbitration, is also more even-handed. Inevitably, litigation in national courts occurs on each party's home turf, or at least one party's home turf, with the attendant benefits that brings to that party. Also, tragically, corruption, judicial corruption, is a very real fact of life in many parts of the world. You can see Transparency International's study of judicial corruption, and if you dig into the statistics on that, it is truly shocking. In many parts of the world, justice is exactly getting what you pay for, and many companies can't and won't do that. Judicial independence also sorely lacking in many parts of the world. And in contrast, arbitrators chosen by the parties, with a presiding arbitrator chosen by an independent and objective arbitral institution or by agreement of the parties, provides a significantly more even-handed means of dispute resolution. Next slide, please. Arbitration also significantly more enforceable than the alternatives. Once you get a decision, the New York Convention means that the counterparty will very often have to comply with that decision. In more than 90% of all cases, parties do that anyway, precisely because of the threat of enforcement. But when they don't, national courts have been quite robust in giving effect to the convention. And finally, next slide, in a post-COVID era, with virtual hearings and the like, arbitration also being more electronic, hearings being conducted online quite effectively, and that in turn reducing the costs, improving the cost efficiencies. And so going back to the Quebec Court of Appeal decision that we looked at a few moments ago, arbitration, the 6 E's, providing the pragmatic benefits that we can see there in the last part of the passage. That in and of itself ought to be enough of an answer for the future. Arbitration provides practical benefits as compared to the alternatives, and therefore ought to be, and in my view will continue to be embraced. But I'd like in conclusion to focus a little bit, just going back on the slide, on the first part of this sentence. Arbitration being expression of contractual freedom, of individual autonomy. And that's a familiar theme that, in a sense, going to the next slide, we've seen for the past 4,500 years. This is Gerard Malines again from the 1680s, referring to arbitration as an expression of free will between the merchants who choose to resolve their disputes in that manner. But in a more fundamental sense, it is an expression of individual autonomy, of some of our most basic civil rights. The law in developed societies, our choices in developed societies, gives individuals, gives you and me the freedom to choose who we'll marry, who we'll worship with, who we'll contract with, how we will structure all those relationships. It underscores the vital importance as part of the rule of law of individual freedom, individual autonomy. All those relationships that we structure, all of us that we structure, inevitably encounter problems. They get broken. They need to be fixed. And just as the law gives us the freedom to structure and choose to enter into those relationships, it gives us the freedom to choose, as women and men have for 4,500 years, how to mend those relationships, how to fix them when they're broken. And the way for 4,500 years men and women have chosen to do that is by individuals that they select, arbitrators, to resolve their dispute. That's not the view that everyone takes. The National Socialists thought that they knew better. They thought that the state had to control everything that individuals did, that arbitrators chosen by the parties were threats to the rule of law and the state. The opposite is true. The next slide. Fortunately, following World War II, German courts, this is the German Federal Labor Court, reached the opposite conclusion, relying on, if we look at the next slide, the second article in the German Grundgesetz, the German Constitution, which provides a constitutional guarantee of individual autonomy. The Federal Labor Court held that arbitration agreements to arbitrate future disputes, were valid and enforceable and constitutionally guaranteed. Next slide, please. The same thing happened in France, notwithstanding decisions like Prunier and earlier French constitutional doctrine, if we look at the next slide, in the Constitution of Year One, provided that the right of the citizens, the French citizens, to resolve their disputes by arbitration couldn't be infringed. And following, again, the Second World War, the French Court of Cassation turned away from Prunier versus Allianz and instead, in a series of decisions, gave robust effect to exactly what the Constitution of Year One promised, the right of citizens to arbitrate. And other decisions around the world, and we can go through these last slides very quickly, said exactly the same thing. And so as we look towards the future, it's not just the pragmatic benefits of arbitration, the 6 E's, which are important, that ought to enable arbitration to continue to be available, but also, more importantly, its fundamental role in preserving our civil rights, our ability to make use of the rule of law. And so when you ask me, what does the future hold? I think it holds international arbitration. And I thank you again for having paid attention to me this morning.
Thank you, Mr. Born. With this, we would like to open the Q&A session. So in case, for this short period of time, if any of you have the questions now or later during the break, you can ask Mr. Born, as he already indicated. So.
Well, thank you for coming and giving such a great lecture for us. My name is Sana Lakaric. I'm a lawyer. I have a law firm, and mostly for my 25 years of experience working with the national jurisdiction, not arbitration, but also working a lot with international companies and foreign investments. What is my view of arbitration or knowledge about arbitration is this country is absolutely not aware of that existing aspect of legal life somewhere in the world. We lived quite a long time in the ex-Yugoslavia in really close society, where we actually didn't know which conventions our government signed and which rights we have.
That happens everywhere.
I know, but I'm talking about ex-Yugoslavia or Bosnia and Herzegovina now. Well, my question, to be quite concrete, we are aware of challenges in various countries, especially here in Bosnia, is how to share this knowledge to the government and to the private investors or the, let's say, decision makers. Because I'm absolutely sure that no one knows the responsibilities and obligations. Do you have any recommendation? Is it through lecturing? Is it through universities? Is it to the public debates? Because people are absolutely living in the dark in this country, not knowing the facts and responsibilities, what means agreement between Bosnia and UK and protection of foreign investments. Thank you.
That's a great question, and it's important not just here in Bosnia, but I think everywhere. In a sense, that excerpt on the slide that I put up about the dark chapter in U.S. legal history is one that, like many of the other slides, has universal application. Unless people discuss, are aware of both international treaties, but also national laws, darkness prevails. And what darkness brings sometimes is the National Socialists or the Donald Trumps of the world. I think all of the things that you mentioned, public lectures, universities, discussions in particular with local courts and politicians, together with lawyers, are important parts of a solution. Fortunately, we have the capacity to do that here with the local arbitration and local law firms to organize events, and I'm sure many people from outside Bosnia, outside former Yugoslavia, would be happy to come and participate in that. Obviously, those sorts of discussions need to be bilateral in a sense. One isn't teaching judges. Judges don't much like to be taught. One is discussing with them and exchanging ideas with them. And the truth of the matter is one learns very frequently also from judges. It is truly a bilateral street. So I think that kind of dialogue is important and welcome.
Thank you very much for the inspiring speech and really putting things into perspective. You have traversed a lot of millennia, so it's very good to know where we started from and why it's worth it. But going back to the recent developments and seeing arbitration from a policy perspective, we do know ultimately it will be what the states decide in national legislation, also in practice, the way that they approach arbitration. And aside from the EU policies, which are well known to our region, in the US, in addition to Donald Trump, there have been other politicians, senators, for example, Senator Elizabeth Warren, who has called for the abolishment of investor-state arbitration. She has called for, pronounced it as an evil, as something that is detrimental to the public policies of the US more generally. So in this intersection between the state's right to regulate and in international arbitration and ISDS in general, do you see a solution beyond these two opposing narratives? Those of us who support it and consider it worth it, and others who are in the policy seats and are fighting to abolish it. Can we accommodate both at the same time?
So I think that's an excellent and also very, very timely question. As we've seen from the slides, much of the recent, not all, but much of the recent darkness about international arbitration, about arbitration more generally, it has focused on investor-state arbitration. Not so specifically international commercial arbitration arising from contracts between businesses, rather investor-state arbitration, where a state promises to arbitrate a whole range of future disputes under principles of international law with whatever foreign investor has made an investment in its country during a specified period of time. And as the question rightly points out, both the political right, Donald Trump, and the political left, Elizabeth Warren, Vladimir Putin, Hugo Chavez, have criticized investor-state arbitration on the basis, and I hate to say this, but on the basis a little bit like the National Socialists, this interferes with our governmental ability to regulate policies within our territory, and we want to be responsible for that. We don't want international tribunals to meddle in our domestic affairs. And the question is, in the face of that criticism from both the right and the left, I would suggest the extreme right and the extreme left, but perhaps it's only the right and the left, what should be done, what can be done? First, I think what can be done is, in a sense, what the second half of my lecture tries to do, to argue with the philosophical basis for that In fact, arbitration doesn't threaten the rule of law, doesn't interfere with democratic governance. On the contrary, gives effect to that. And that it is particularly important in international investment matters because foreign investors lack the standing that domestic parties do with respect to local government decisions. But there is also, I think, a need to recognize that those early bilateral investment treaties going back to the Germany-Pakistan treaty were a little bit like the New York Convention, experimental. Experimental in the sense that there weren't ready models that preceded them. There actually are antecedents to those bilateral investment treaties, but in a way, those early bilateral investment treaties, many of the 2,600 that we saw on the slide, many of those treaties were quite simple in their terms. They were not drafted with precision, in part because the drafters of those treaties were exploring uncharted territory. And so, both with respect to the procedures in those arbitrations, but also with respect to the substantive guarantees, the drafters of the treaties used extremely broad language that was susceptible to being interpreted in a variety of different ways. That's not to criticize those drafters. They were doing something that was novel. They were doing something that, in my view, as this lecture suggested, was noble. It was a very important step in the development of international law. It embedded protections, fundamental protections for international human rights, protections for against denials of justice, protections against expropriation without compensation. Fundamental human rights were protected in those treaties, but they were done in very broad terms. And therefore, in trying to find a middle ground where the critics on the right and the left can at least in part be addressed, one, I think, can look to new generations of treaties, and later generations of treaties have begun to do this, to define, because at the end of the day, states are free to define what sorts of rights they give to foreign investors, to define those rights and those protections with more precision. If there are concerns about the scope of fair and equitable treatment, one can define more specifically what fair and equitable treatment means. If one is concerned about aspects of the arbitral procedure, as the Osgood Declaration supposedly was, you can address how the procedures in an investment arbitration will be conducted. Is it to be confidential or should it be transparent? States actually have very different views about that. Some states, the United States, for example, says that it wants its investment arbitrations to be public. In fact, sometimes when you talk to government officials, that's not really what they think. But many states in the world, irrespective of what U.S. negotiators might posture, many states in the world don't want their investment arbitrations to be confidential. And thus, states in their bilateral investment treaties addressing what it is exactly they want, both in terms of confidentiality, but also in terms of arbitrator selection, in terms of arbitrator procedures. How fast should the arbitration go? What sorts of disclosure obligations and rights should there be? What sorts of privilege should there be for the states? All of these issues can be addressed. And in a sense, that would be a very natural and sensible evolution. Early treaties that provide a first step towards investor-state arbitration without specifying the details. After now, it's been 60, 70 years since the first bilateral investment treaty, after those 5, 6 decades of experience, providing for more precision in treaties would, I think, go at least part of the way towards addressing the Donald Trumps and Elizabeth Warrens of the world, at least if they are genuine in their concerns about procedural issues.
Thank you, Mr. Boren, and thank you for the questions. Now we will invite you to have the coffee break in the room next door. And later we're going to have our first panel. And after the first panel, it's going to be lunch served here. So we invite you cordially to first now have the coffee break and then stay with us for the first panel. Thank you. Thank you. Ladies and gentlemen, well, we hope you had a nice coffee break, and now we will continue with our first panel. The first panel we would like to welcome today here with us, starting first with Ilya Penchulisky. Ilya is a partner in the Paris office for Three Crowns, an international law firm comprising of 80 lawyers practicing exclusively international arbitration. His work focuses on complex investments and commercial arbitrations, particularly in the energy sector. He has represented states and investors in some of the largest and most politically charged arbitrations, including having acted for the former Yukos shareholders against Russia under the Energy Charter Treaty. That dispute resulted in the highest award in history, amounting to USD 50 billion. Ilya teaches also international arbitration at the University of Freiburg in Switzerland. He holds an LLM from Harvard Law School, Magister Juris from the University of Oxford, and an LLB from St. Cyril at Methodius University. Next to him, we are very happy and proud to announce that we have Philip Baltazak, an LLM PhD attorney at law who is admitted to the bar in 2 jurisdictions, Poland and Spain. He is an associate professor at the Adam Mackiewicz University in Poznan, Poland, and a partner at the Polish law firm SSW Pragmatic Solutions. He has been included in the European Commission list of individuals eligible for appointment as arbitrators and trade and sustainable development experts in bilateral disputes under trade agreements between the European Union and third country. Philip acted as an arbitrator in 35 cases, as presiding arbitrator, side arbitrator, sole arbitrator, and emergency arbitrator. He is included in the list of arbitrators at 2 major Polish arbitral institutions, the Court of Arbitration at the Polish Chamber of Commerce and Levitian Court of Arbitration, as well as leading international arbitration institutions such as Hong Kong International Arbitration Center, Shenzhen Court of International Arbitration in China, Energy Disputes Arbitration Center in Turkey, Riga Arbitration Court at Latvia, Qatar International Center for Conciliation and Arbitration in Qatar as well, and the Arbitration Foundation of Southern Africa International Court in South Africa. He has also been included in the arbitrator database of the London Court of International Arbitration. He has authored numerous publications on international investment arbitration, including 2 monographies, which are Renewable Energy Arbitration, Quo Vadis, Implication of the Spanish Saga for International Investment Law, and Investor-State Arbitration and Human Rights. Welcome. Next to him, we have with us today Pierre Trippel, who is a partner at Aurelius Cotta. With a wealth of experience in both litigation, investment arbitration, and commercial arbitration, he's well-versed in handling intricate cases. His practice primarily focuses on resolving complex investment and commercial arbitration cases, advising clients in complex cross-border disputes in the banking and energy sectors. And the moderator for today with us is Fahira Brodlia. Fahira Brodlia is the rule of law advisor for the regional GIZ Legal Reform Project, focusing on investment disputes in the Western Balkans, and a member of Association Arbitral. We will now like to open the panel. Thank you.
Thank you very much, Ayla, for your kind introduction. It is a pleasure to be able to facilitate this discussion among such experts, because in such a complex field, we do indeed need multidimensional views, and the experience and expertise we have on this panel will be definitely suitable for this purpose. For anybody who is following investment arbitration in any way and who is interested in the renewable energy policies, it would appear that investor-state dispute settlement, or ISDS, is dominating the discourse. And if you read some of these bombastic headlines, you might think that if ISDS did not exist, then the climate change issues would disappear, the environment would recover overnight. And on the other side, you have defenders of ISDS who claim that all of this is absolutely non-founded, and there's a lot lost between these two narratives. And the kind of reform that will be necessary will require a lot of nuance. So today on this panel, we don't promise any answers, but we will promise a nuanced discussion about some of the key issues. And why should we even care about renewable energy disputes in the Western Balkans in general? It is because when we see bigger states, richer states, EU member states who faced backlash from investors after renewable energy reforms, we actually see just how far and how difficult challenges might arise in this context. And Spain is the most vivid and most expensive example that we have to date, at least in this sector. After the robust and quick, diverse reforms that they introduced, they have faced between 50 and 60, reporting is different, but it's an immense number of investor claims that are, some of them are still ongoing. And to date, they owe close to $2 billion in damages just for these cases that have been concluded so far. Luckily, today with us we have Philip, who has literally written a book about the concluded cases, taking a very nuanced view on all of them in order to come up with a global picture, which we all need as lessons learned from these cases. So Philip, please, the floor is yours if you don't mind introducing us to some of these issues.
So thank you very much. I hope I will be heard, and I just remind myself that we have agreed for a certain time restrictions, which I will try to comply with. And good morning, first of all, good morning everybody, and it is a real pleasure to be here and to have the possibility of presenting a few thoughts in this panel, which we named as Renewable Energy Disputes in a World Without the ECT, how to avoid the Spanish scenario in the energy transition. But in order really to think about how to avoid the Spanish scenario, we have to understand first what happened in Spain and what lessons can we learn for the future from these cases. And this is what I would like to start with in the first place. If I could, yes, thank you for the next slide. And the question is, why this topic at all? And the question can be divided in two parts. So why renewable energy and why Spain? I would like to start with the first part of the question, so why renewable energy? And I would like to invite all of you to take a step back and look at the energy itself, regardless of whether it comes from fossil fuels or whether it comes from clean sources. Energy is described as the backbone of our economies, but not only. So we use it in our daily lives. Right now, when we are sitting in this room, when we are looking on the phones, when we are looking on the laptops, when we watch Netflix in the evening, when we cook our dinners, we use energy all the time. And in that way, I think it's fair to say that as a humankind, we are addicted to energy. And from the perspective of the energy supply, renewable energy is more important than ever, because there is a visible shift from the petroleum-centric character of energy investments to renewable energy, and the process of decarbonization is a fact. And the fight against the climate change is actually doomed without renewable energy. And this is happening around the globe, not only in the European Union. And from what I have learned, also here in Bosnia and Herzegovina, there is a debate, for example, about the introduction of the National Energy and Climate Plan to comply with the EU Green Deal and to be able to continue to export energy to the neighboring EU member state countries, which is in line with the Sofia Declaration on the Green Agenda for the Western Balkans from 2020. So also here in this part of the world, the topic is more important than it has ever been. So the growth of investments in renewable energy sector means that there is also a growth of number of disputes. Many of them will be horizontal in nature. So there will be disputes between investors and their contractors, between the contractors and the suppliers, between shareholders, between members of the joint ventures, and so on. But this is not the end of the story. So another layer is a vertical relationship which happens between private parties and states. And this is of particular importance in the renewable energy sector for a number of reasons. One is that states introduce incentives and subsidies and other forms of mechanism to encourage growth of renewable energy investments. Second, renewable energy investment sector is highly regulated. Third, sector requires long-term investment. So business plans require planning for 20 and more years. Fourth reason is that it is a capital-intensive investment, but about 90% of the costs are paid upfront. So before any revenue is generated. And because of these characteristics of renewable energy investments, we can see a phenomena which is described as the hostage effect of sunk investment. So some describe this as almost irresistible temptation on the side of the state to change rule of the games once the investments are made. So once the state is happy with how many investments have been made in the sector. And another part of the question is, why do we look at the example of Spain? Because we can look on many examples: Poland, Czech Republic, Italy, Romania. But what is so different about Spain are the numbers. So as Fahira said, we witnessed the highest number of cases against a particular state, which allow us to calculate that approximately 80% of all investor-state dispute cases in renewable energy sector concern Spain. And I think that Spain can serve as a model example for the analysis for 3 reasons. All of the cases concern the same disputed measures. So what state did is challenged in all the cases the same disputed measures. Facts of the cases are essentially the same. Of course, with some nuances about when the investment was made, whether it was hydro energy, whether it was solar energy, whether it was wind, but facts are basically the same. Investments have been made, and then the legislation has changed. And because of this, I invite all of you to consider Spain as a perfect model example or as a laboratory for lawyers, so we can see law in action, which is in action with respect to the same facts, the same disputed measures, and the same applicable treaty. And in that sense, it gives us this opportunity to identify lessons learned for the future, which are relevant globally. So they are not relevant only for Spain, they are not relevant only for European Union, they are relevant for everybody around the world. Even if the ECT at some stage dies, which apparently it will be, the wording of these cases will be applicable or will allow to apply these lessons learned also to treaties other than the Energy Charter Treaty. So I know that Bosnia and Herzegovina is party to 39 bilateral investment treaties, and they will continue to be enforced. So these lessons can be learned and applied also for the future based on these treaties. So as we have heard on the keynote speech, if we don't remember about the past, we are condemned to relive it. So if I could ask for the next slide. Yes, thank you. So in very short term, Spain is a history of a success becoming a problem. In very few words, what happened in Spain is that Spain wanted to incentivize investments in renewable energy, a sector, in order to meet its obligations in different fields of international investment law, its obligations under EU law, but also to be in line with the United Nations Framework Convention on Climate Change and the Kyoto Protocol and then the Paris Agreement and so on. So the story goes back to 1997, where we have a new law applied, and regulations adopted based on this law were not sufficient to attract enough level of investments in the field. So regulations were changing, and the outcome was not the desired one. So 2007 is the moment in time when Spain adopts Royal Decree 661/2007, which is the story of success. It reshaped the old regime, offering an attractive incentives at a higher speed than anticipated. So just to give you example, only 3 years later, in 2010, Spain accounted for half of all solar power produced around the world. Among many other features, what was important in this decree was that it guaranteed that any future revisions of the regulatory framework would not affect the investments which were already accepted in the system. And this was the principal feature of the system which led to future problems. Just 1 year later, 2008, global financial crisis hits Spain in a very hard way, and is one of the reasons why Spain starts to suffer a phenomena called as tariff deficit. And this tariff deficit became a problem on political agenda. 2011, we have a new government, and just a few weeks later, the new government starts to change the policy, which culminates in 2014 by adoption of a new regime. And the new regime replaced totally the special regime which was in place before, and is based on model facilities. And these model facilities defined in new regime as an efficient and well-managed company. So it's detached from everything what was important before and is detached from the costs actually involved by each of the investor. And it is based on a concept of reasonable rate of return, which is supposed to be generated by these facilities. With this introduction, we can learn a number of lessons for each stage of arbitration, so jurisdiction, merits, and remedies. As regards the jurisdiction, I will skip the first lesson, which is relevant for the EU context, which is not yet relevant for Bosnia and Herzegovina, but let's look on the second lesson learned, which is tax carve-out objection. So basically, ECT is a treaty which contains the so-called tax carve-out, which means that if a state adopts a tax, this tax is not subject to arbitration. But what we can learn from the Spanish saga cases is that it is not sufficient to name a measure a tax, really to be able to move it away of application of investment treaty, which is the basis of the claim. So these cases confirm that in order to analyze any tax, we have to look what is beyond the level of this particular measure and whether this measure complies with three elements of definition of a tax under customary international law, which is that it has to be established by law, it must impose an obligation on a class of people, and involve paying money to the state for public purposes. So what we can remember in the context of Bosnia and Herzegovina, for example, is that if a state adopts a measure which is targeting a specific individual entity, then probably it will not fit within the definition of the customary international law, and as such, even if it is named as a tax, it will probably not be considered as a tax under definitions of customary international law, and therefore will be subject to or within the scope of jurisdiction of arbitral tribunals. Next lessons learned, I propose to focus on fair and equitable treatment, where in the Spanish cases we can see in theory three groups of cases. So cases which dismissed the claims and cases which upheld the claim for violation of fair and equitable treatment in full, and those claims or those tribunals which decided that the FET standard was violated, but only to the extent that the new regime did not guarantee the concept of reasonable rate of return under the new regime. So what we can learn, but this three group of cases, this is something which is apparent, because in reality we can see two cases. So those which upheld violation of fair and equitable treatment in full, and those which limited it to the concept of reasonable rate of return. Because the three which dismissed, they were dismissed based on particular facts of these particular cases. So without entering into details, we have these two groups of cases. And in short, they are rooted in different interpretation of Spanish law. So without entering into interpretation of which approach is more relevant from the perception of Spanish law, what is important is that Spain did not deny that legitimate expectations understood as part of fair and equitable treatment can be based on legislation. So this is a quotation from a submission in one of the cases where Spain basically argues that yes, you can expect something based on legislation, but this is something else than the claimant argued. So this is the first, if you can move ahead a little, because I know that I'm running out of time, I have 1 minute more. We can learn that cases with legitimate expectations understood as element of the fair and equitable treatment can be based on general legislation. This is true, and this is what we learn from the Spanish cases. The second lesson learned is what is the scope, right? So if you can move to the second lesson, yes? Next one, please. Yes. As regards the scope of what exactly this legitimate expectation means, here the concept of what we understand as reasonable rate of return under the Spanish law, this is not relevant for us, really, in concept outside of Spain. But what is relevant, that it would be a truism to say that we have to look on domestic law. So we cannot simply take what the cases say about reasonable rate of return and then apply it somewhere else. So what is relevant, what is stated in local laws. And if we can move to the third lesson, Land. So it's again the due diligence. So in order to base some expectation and protection on international law, on ECT, on the stability, we can expect that investors conduct due diligence. So due diligence is essential to establish this protection under international law. And again, in Spanish cases, we can see different approaches. In general, there would be two groups of cases. One group will say that you have to do the due diligence. Other group will say you don't have to do due diligence, but if you don't do, your expectations will be assessed compared to knowledge available to a particular investor who would have taken the due diligence. So what we can learn is that you have to perform due diligence if you want to have legitimate expectations protected under bilateral investment treaties or the Energy Charter Treaty. And if you do not do it, it doesn't mean that an investor loses the protection. It simply means that something which he should have identified and he didn't because he was ignorant will be taken into consideration by the arbitral tribunal in case of a possible dispute. In the book, of course, there is a number of other lessons learned, but for the sake of time, I suggest that we will stop here, and I will just thank you for your attention and invite for the discussion.
Thank you very much, Philip. Indeed, the book is very rich with information, and this was a very successful attempt to condense it to the key points. Many things to be learned, and we mentioned earlier the state's right to regulate and how that's one of the key focuses of the criticism of ISDS. And it's very important to note, as you did, that in this case, it was actually regulation that worked too well, too quickly, and the state then had to retroactively amend this. So it was all within the scope of the state's right to regulate, and yet it did not work as planned. And we can get back into discussion to maybe what you recognize as the key problems with the legislation itself. What was the cardinal mistake that they made from the tribunal's perspective that put them in a position of liability later on? But thank you so much for this wonderful background. And you did touch upon a very important issue as well, which is the nature of these investments. What is so characteristic for the renewable energy sector that makes it at the same time so important but also so risky for the states as they're trying to engage in these important policies? And we're happy that Ilya has been willing to share with us some of these ideas in general, to give us an overview of what it looks like from the sectoral perspective, but then also a little bit narrower in the Western Balkans context. So please, Ilya, the floor is yours.
Falls upon me to discuss the question of the Western Balkan experience, but to arrive there and the risks that may be seen in the renewable sector for the state as regards significant arbitrations in the renewable sector. But before we get there, as Fahira said, and thanks very much for your introduction, as Fahira said, I think there's some basic information about two things that we need to perhaps broach. One is a little bit about the economics of renewables and the key drivers there, and the second is what exactly does the state do to incentivize renewables, why, in what context, and then we can look at what's been happening recently in the Western Balkan states, how they've gone about supporting renewables, and what risks may loom for the states here and for investors at the same time. So, very briefly, the 3 points which I've outlined are on your screen. Moving straight to the first one, as Philip mentioned, this is a capital-intensive market with significant exposures. It takes about $20 million to build a 20 megawatt solar plant, with ROI going, return on investment, sometimes being between 7, 8, 9. In case of wind, it could be a lot longer, 10, 15 years. So the question that we can pose ourselves, we can move to the next slide, and then that's just the basics of the business. But moving to the next slide, the question is how can renewables be viable? Can a renewable project be viable exclusively on supply and demand market economics? And the history has been not in favor of solar. As you can see on this graph, we have at the top on the left, that's the cost of producing electricity compared to based on solar input. And at the bottom, you have fossil fuel costs of electricity. And historically, solar energy has not been competitive with solar. Solar energy has not competed well with fossil fueled energy. And so, in recent years, technological science has been doing its thing, right? We've had significant technological advancements over time in the production of solar cells and so on, and there has been phenomenal R&D for good reason that has led to a decrease in the power. If you could just stay on the previous slide, please. That has led to decrease of the price of solar. You have an uptick at the end in 2020. You have an uptick in fossil fuel generated electricity, which is largely connected with what we've seen in Europe with the Russian invasion in Ukraine and the phenomenal increase in gas and oil prices. So that uptick doesn't have to do with some kind of a technological problem with fossil fuels. It's purely a reaction of the current geopolitical situation in the world. But looking at the next slide now, you will see that historically, solar and wind have required significant support from the state to be competitive against fossil fuels. And that has, over time, gradually decreased. But the situation is largely, it's still such that solar and wind energy do require state support to be able to displace fossil fuels. Now, if you can now go back to the previous slide, if we look at this previous slide, as I mentioned, there is this uptick in fossil fuel energy, but that is a reaction to what happened in Europe and in Ukraine. And what happened after that? You had probably somewhere between 8 and 20, I think, long-term gas agreements concluded with the US. The Appalachian Basin in the US, with shale gas, has the biggest reserves of gas in the world. The moment there is a dip in supply in Europe, you have oil and gas reorienting itself towards this region, which will affect prices of fossil fuels. Ultimately, we might not see 2020 COVID values of oil and gas, but that's going to drop, and you can bet that oil and fossil producers will seek to be competitive with renewable energy. This means that there will be new pressures from oil and gas on solar, despite the thing that we see there. And if we go now 2 slides down, it's not the only pressure that's on solar and wind. The world is such that we have supply chain problems. We have massive inflation in recent years. And I've just cropped on the screen a few Financial Times headlines from the past 2-3 months. And look at this. It's doom and gloom for offshore wind. You have Siemens Gamesa, one of the biggest German companies, reporting losses of around 10 billion in wind. You have Ørsted, the largest Danish player in offshore wind, that has had to pull back on massive projects in the US for reasons of inflation and supply chain issues. And they say, well, we have this economic situation where supply chain and inflation push us to the brink, but we don't have a step forward to us from the States to help us deal with this. And so we're going to have to shut down these projects. Now, the bottom line for me is this. Number one, as I mentioned, there will be pressures from oil and gas producers. Number two, there will be massive economic challenges that are independent from oil and gas. Number three, and this is something we need to very much be aware of. I forget the numbers now. I think that there are some, I don't know the exact amount of installed capacity that's currently in solar and wind around the world, but by 2050, to even be dreaming about the kind of parameters we're talking about to move from fossil to renewables, the investment needed is $6 trillion just to be able to get to, I think, 85% renewables generated energy. What does that mean? It means that given the economics that I've just explained and the impetus of getting to a renewable energy produced, renewable produced electricity, we will have massive state support, or will need it, barring any, a trifecta of a technological, political, and economic wonder. You will have a situation where the state will need to very seriously subsidize renewable energy. That's a fact. So how is that done? And we can look at that very briefly. There are multiple ways, but I've just set out the 4 key ways in which a state can subsidize renewables. One is a feed-in tariff, which is basically you get a fixed price for your electricity. A feed-in premium means you get the market price of electricity, but you get a top-up, a little bonus, because you're a renewable producer. The fourth one is there's an auction. You set up an auction. I want this much renewable capacity, and private investors will then bid. I will build this solar panel of so many megawatts if you give me this price. And we'll talk a little bit more about auctions. And the fourth way of doing that is through tax credits, giving companies tax breaks, VAT breaks, and various tax allowances. So let's look at the Western Balkans and how they're doing things. Before that, at the screen, you have the energy generation in this region. And so the first thing you'll notice, if you go to the top, to the bottom right corner of this table, is that the Western Balkans produce more renewable energy than the average European Union states. That's an interesting fact, but of course it's not telling on its own, because if you look at the first column and the third column on coal and natural gas, you will see that the Western Balkans produce a lot more from coal, they produce a lot from oil, and very little from natural gas. And so between the 3 fossil fuels, natural gas is the cleanest. We are using the dirtiest fuels in this region. So that will have to go. And as you all know, in the region, we've had significant support in recent years for renewables. And I of course will not, if you go to the next slide, I will not look at each of the measures individually, but I've looked at them, and this is my attempt to sort of summarize what's happening, and it may be an oversimplification, and people here from the region will certainly know better than me exactly how these measures work. But my understanding is, number one, there is a move away from fixed feed-in tariffs. There's a moving away. You have that in at least 4 countries that I've looked at. Serbia maintains a fixed tariff, though there are recent changes now. They have maintained a fixed tariff for about 12 years. So you have 12-year contracts that allow you to get this feed-in tariff. But as of this year, they've all opened the possibility to receive renewable projects through auctions, and we'll talk a little bit more about that very shortly. Now, what's the interesting thing about Serbia is that renewables producers have opted out of the feed-in tariff because it's been too low, and they have actually gone onto the market and gotten the market price. So those fixed tariffs haven't worked in Serbia because what was bargained was too low. The same situation in Albania and in North Macedonia and in Montenegro. You have a preference for the premium on the market price, less so on the the feed-in tariff. And though they are still using feed-in tariffs for smaller projects too, so that smaller producers are stimulated. So there is a decline of the role of the feed-in tariff, and now if we go to the next slide, there is an increased role for auctions. And now in Serbia has opened an auction for 1 gigawatt project, which is obviously a significant investment. And as far as I know, the current bidders are American and Chinese. The same thing is happening in Macedonia. There's preferential treatment to strategic investments of this sort. Kosovo is currently accepting bids for a 100 megawatt plant for 15-year power purchase agreement. I forgot to mention this when we talked about auctions. What happens when you have an auction is you get a contract, usually with the main utility company in the country, which means that you then have a contract in which you're guaranteed a certain price or a premium on top of the market price. Okay, and Bosnia as well has been auctioning as of this year, I understand, some fixed feed-in tariffs for smaller renewable plants, and then it's also for large projects. So going to why we are today, and how do we compare the situation here with the Spanish scenario? I mean, there are a number of differences that we see between Spain and here. Of course, there are 2 massive technological and economic drivers that led to the Spanish situation. One is that from the moment when Spain granted the subsidies, there was a technological revolution, and 2, there was also, as you explained, a economic crisis. So those 2 factors led to the investors taking Spain to arbitration for the significant changes to Spanish legislation that were done several years later on. Now, what is the situation that we see here? Because of the rise of auctions, you can control 2 things in the Western Balkan market. One is you control how much capacity you can contract. So you don't over-contract, over-subscribe to renewable capacity that your market cannot support. That's number one. So that is an alleviating factor. The second thing is, when you have an auction, it's a competitive bid to a degree. And in some states, the state can set a cap. So you cannot bid over that cap. You have to bid below it. So there is an element of economic competition when you get into these auctions. Another thing that's different to Spain, the period for which subsidies are provided here is shorter. So you're not committing for 20-25 years. And the commitment doesn't come in legislation, but it comes in contract that's specifically negotiated once there's a bid, right? So that's important, but it also exposes the state in other ways. We'll talk about that very briefly. Now, the last point is, what I understand is that even though there has been a phase out of feed-in tariffs in the region, those past feed-in tariffs that have been committed to by the Western Balkan states are generally respected currently, and even in cases where there is a phase-out, there are mechanisms to ensure that the previous commitments are respected. And Albania is an interesting example in this regard, which is that where they've moved away from feed-in tariffs and they've gone into a different model, what they've done is they've entered into contracts that specifically top up the investors and provide them an additional compensation that they would have gotten had they still been under the feed-in tariff. Okay, so that's the situation. So there are important factors that distinguish this region's legal framework and current outlook as compared to Spain. But what are the risks? Okay, the risks are given what we've described. I think that there are plenty, of course, but let's look at some of them. Number one is that it's a very live industry. It's extremely regulated. There's political changes here. So there's a risk of roller coaster regulation, changing things, new political parties coming in, changing things, giving projects to favored players. So there is a risk of roller coaster regulation, which could be contrary to international treaties. Secondly, there is, of course, the possibility of the state not honoring feed-in tariffs, just as it was found in many countries in Europe. So that's a risk. Now, you have contracts. You have to, pursuant to the auctions, you enter into contracts with utilities. There's a double risk there. Number one is the contract itself will create legitimate expectations. Number two, it will contain an arbitration clause sometimes. And so it is possible for the state to have a double whammy suit, both under the contract and under investment treaties. And you may find yourself in a situation where you've oversubscribed to renewable capacity and you have to terminate contracts. So it's very important how those will be negotiated. You could also have auctions being tampered with and given to preferable investors. That happens everywhere, not only in this region, but it could happen in this region. And so that's another risk. And there have been, in fact, lawsuits against Canada for discriminatory auctions, which haven't yet led to fruition for the investor. And then lastly, you can give someone a contract under an auction, but then you deny them the permits that they need to be able to pursue this contract. That can, of course, be a problem under investment law as well. And that has been, as I've mentioned, Canada has been found liable under an international treaty for having done exactly that. So I suppose, at least from what I've been able to glean, I think there are obviously some significant differences between the region and Spain and the Spanish scenario. I think that there is also a lot of acute attention to these problems here, and again, there is no room, in my view at least, for self-deprecation on the part of people from this region to say, well, you know, what do we know better than Spain or not? I think there are many smart people in the administrations of these countries that are paying attention and are looking at things the right way. The problem is really when politics and favoritism comes into place. So I'll stop there, but that's sort of the sense I've gotten. Thank you.
Thank you very much, Ilya, for narrowing and zooming into the regional risks and issues, because we heard a lot about the worst case scenario, what happens when you do regulation in the wrong way, even though it has the right intentions, that it was following EU policies. And on the other hand, how important it is to understand specifically what could arise in the Western Balkans. Because if we look historically at our cases, most of them were not challenges to regulation, nor were they challenges to laws. They were challenges to administrative measures, or lack thereof. And like you mentioned, contractual issues, licensing issues. So before concerns about how we regulate in the future, we need to see what are we doing now in the transition period to administer the move to energy that is more renewable in a safe way to avoid these disputes. So many considerations there. And also a very important moment that you mentioned is that we are actually falling behind in renewable capacities. So in 2015, the estimate was 2.3 trillion annually of renewable investments to meet the 2030 goals. Like you mentioned now, it has actually gotten progressively worse. We are further behind on these goals. And all of the new investors that we will need are those that we are kind of antagonizing right now and that are very concerned about many things, including the ECT. We all know the Energy Charter Treaty is the only sectoral, multilateral treaty that provides energy protection for the energy sector in the trade and investment of energy matters, but also that now it is under extreme scrutiny and questioning. So Pierre, we turn to you with a very easy question that will be an interlude into the debate that we will have after lunch. To give us some guidance about the considerations that go into the question whether or not to withdraw from the ECT as it is, whether to modernize it. And since we are talking about particular experiences, if you can glean into the German experience for us, it would also be very helpful. So please, the floor is yours.
Fahira, thanks for inviting me. It's a pleasure. I think if we have learned one thing from today's keynote speech is that looking at history and arbitration and its rules are subject to constant change. And I think this constant change and sometimes how quick developments can happen is very well seen with the recent developments regarding the Energy Charter Treaty. So ever since 2017 until 2022, states have gathered to negotiate about a modernization of the treaty. And when the modernization negotiations concluded in June 2022 and the new treaty was presented, I think many people thought that this is going to be the way forward. It was envisaged that in November last year, the Energy Charter Treaty Conference meets and actually approves the modernization of the treaty. But this did not happen in that form. What happened was that a number of countries, especially from the European Union, announced their withdrawal from the Energy Charter Treaty. So it started with Poland in August 22, soon followed by the Netherlands, Spain, France, my home country Germany, and then obviously very recently also Ireland, Portugal announced their intention to withdraw, or actually announced their withdrawal. Now the big question is obviously when and if the EU itself is going to follow. One note in that regard is that although now a number of countries have announced their withdrawal, there will still be, at this point at least, more than 40 countries being contracting parties to the ECT. So it is still a very robust and global treaty protecting energy investments. So looking now a bit at the perspective, what led to the decisions of those countries to withdraw from the Energy Charter Treaty, and I want to focus on my home country, Germany. Very close before the withdrawal was announced, a spokesperson from the Green Party in Germany that is actually in power stated, I quote, "This pact," meaning the Energy Charter Treaty, "is an obstacle to the energy transition." And soon thereafter, the federal government stated that, unfortunately, the negotiations for the modernization of the treaty did not yield the desired results. And I think this is important, they stated the Energy Charter Treaty is, in their view, incompatible with the German goal for climate or carbon neutrality. the obligations or goals of the Paris Agreement, and lastly, the European Green Deal. So this might come as a surprise because in recent years there were different reasons why the Energy Charter Treaty and its dispute resolution settlement mechanisms were in the public debate in Germany. So it started in 2009 with the Vattenfall 1 arbitration regarding the permission of a coal plant, and then led to the Vattenfall 2 saga brought by a Swedish investor against Germany for the accelerated phase-out of nuclear energy. So this obviously brought a lot of attention to investor-state dispute settlement mechanisms, specifically under the ECT, into German politics. But now the decision was ultimately because of the energy transition and the goal to become a more climate-friendly country. Now, what happened very recently is that in July 2023, the European Commission also proposed a coordinated withdrawal from the Energy Charter Treaty by all European countries being signatories to it. And in that regard, I think it's very interesting again to see the perspective of the EU. Franz Timmermans, who is the vice president responsible for the Green Deal in the EU, he stated, and I quote, that the Energy Charter Treaty is not aligned with the EU climate law and, more importantly, the commitments of the European Union under the Paris Agreement. Now, what is interesting, that last year in November, the Secretary General of the ECT wrote a letter to the European Parliament at that time, where he stated that when looking at the EU and the disputes arising under the ECT, 76% of those disputes concern renewable energy and not fossil fuels. So, with the goal of the EU and most of the European countries in mind, the question is now what will that withdrawal really lead to, and will it make the energy transition any easier? And I have three observations in that regard. The first one is obviously the elephant in the room, Article 47.3 of the ECT. And I don't want to quote the wording of it, but the important thing to understand is that if a state, like Spain, for example, withdraws from the Energy Charter Treaty, investments in that country that exist on the day that the withdrawal becomes effective will be protected for another 20 years. Now, 20 years is a long time. So another 20 years of protection for investments that were in place at the time of the withdrawal. And such sunset clauses, as we call them, are no novelty in the ECT. The OECD in 2015 published a working paper where they analyzed all, at the time, 2,500 investment treaties, and they found that 97% of them had some sort of a sunset clause, ranging between 5 to 25 years. But the 20 years in the energy field makes sense because, as was pointed out by my co-panelists, the investments in the energy sector are large scale. A lot of the plants require many, many years before they reach amortization and become profitable. So the second point I want to address is that now by withdrawing from the ECT, this doesn't mean that fossil fuels or other energy sources are no longer protected. There is still a vast number of bilateral investment treaties in place by European countries. I think, again, it is, in that regard, interesting that the ECT Secretary General in the letter I mentioned earlier pointed out that in the EU alone, there would be 1,500 BITs in place, all of them containing investor-state dispute settlement mechanisms, and a lot of those would protect fossil fuels as well. So just by withdrawing from the ECT doesn't mean that there aren't other BITs in place that might protect investments regarding fossil fuels. And for Germany alone, there are, for example, 19 BITs in place with other Asian and Eastern European countries that are also member states of the ECT. Now, the third and final point is that the withdrawal from the ECT, of course, also means that there is no longer protection for energy investments under the ECT in the future after the withdrawal becomes effective. So, especially in light of, I think, the common sense that the energy transition is going to require enormous investments in the energy field, there is a certain need for investors to have legal certainty and also protection of their investments. So with the ECT no longer being in place, there's certainly going to be a dialogue amongst investors and states to see whether the protection mechanisms in place are reliable and sufficient. And investors may also make new risk analysis for certain investment in regions. Because ultimately the protection of the investments, especially if they're so large scale and long term, are very important. So I think if there are just two key takeaways, the first one is that really legal protection for hydrocarbons, but also for renewable energies investments for countries that were a part of the ECT. They still both exist for another 20 years for investment made prior to the withdrawal. And second, also in the future, under the existing BITs, there will also be protection. And the second one, now with the withdrawal of the ECT, will certainly lead to a more nuanced dialogue between investors and states to figure out what protection mechanisms should be in place to adequately protect foreign investment. Thank you.
Thank you very much, Pierre. And with each panelist, we have heard a whole panel discussion and things we could discuss for the whole day. We are a little bit behind on time. I will open the Q&A, a short Q&A, so we don't hold you back from lunch for too long. But I do want to press just on one question and seek anybody who would like to comment on this, because one of the most perplexing questions about the withdrawal of the EU member states and anybody considering, not looking into the modernization, but rather withdrawing from the old one, is the sunset clause issue. How do we square the circle of the EU and its member states claiming that the policy background for the withdrawal is the inadequate protection of renewable energy investors and the disproportionate protection of fossil fuels, while at the same time refusing to support a modernization that will shorten the window of their protection and instead of getting locked into the sunset clause itself? Is there any way to rationalize this? And I don't expect a direct answer, but just what would you consider to be the balancing act there?
Is it a rhetorical question?
I don't know. Let's see. Just try to press it.
So for those of you who were here last year, we had a similar discussion on this. Exiting the ECT is a little bit like the low-hanging fruit solution, in my view, for states. It takes impossible effort to move away from fossil fuels, and not only in power generation, but in every aspect of our lives, in production of steel, in fertilizer, shipping, trucking, you name it. It's not something that can happen overnight, but the political pressure, the voter pressure, we all feel it. It needs to happen soon, and there's a lot of pressure on states. So it's an easy solution. I'm just going to get out of the ECT. And then say to everyone, well, it's a treaty that protects fossil fuels. We've discussed this last year. It is an obviously much more effective solution if you had reformed the ECT to allow more protection to renewable energy, and to phase out the protection quicker of fossil fuels, which was on the table. That was on the table. And then there's the paradox of the sunset clauses that you mentioned, because when there is individual states exiting and not the whole block of energy charter treaty members, the risk is that those states that have exited in that way will be bound by the sunset clauses. But if they had jointly modified those clauses or even removed them from the treaty, they could have perhaps achieved another result. It's at the very least arguable that those, even if this happens later, those states that have now pulled out will owe their obligations under the ECT at least to those who finally will not. So it is a contradiction, but politics is like that.
Mm-hmm. Very comforting political answer. Any other comments?
Yes, maybe I will just comment that I don't think that the politicians see it as an issue, in the sense that since the intra-EU aspect of investor-state arbitration is assumed to be ineffective, mm-hmm. and the vast majority of cases brought against the EU member states are intra-EU, I simply don't think that it is perceived as a problem. Mm-hmm. So if there is no problem, then you don't solve it.
Here, do you have any?
Yeah, I think to me the interesting aspect is really the way forward. Decisions have been made, and so I think now the interesting thing is how do we secure the energy transition in Europe and also globally? How do we secure these investments? How do we balance the interests of sovereign states, namely what states say to regulate, with the interests of investors to have protection? And I'm certain, as history has shown, that there will be new developments, there will be new instruments, there might be new modernized treaties that afford different protections that might even be more favorable for all parties involved. So I think this is sort of establishing facts, and now the important thing is to look forward and get all stakeholders together to find new solutions.
Absolutely. I think it's a very important message towards the conclusion of this panel, that we should not lose sight of what this all is about. If we are talking about energy transition and creating a legal framework for it, the battle about ISDS will be handled at the national level in any case. They will decide state by state whether they want it or not. But the whole purpose of the movement is to enable the necessary investments, to provide the protection. Especially like Ilya mentioned, there will need to be a lot more communication between the state and the investors. Those investors who might expect something based on the older regime, if they're engaged properly in discussions, then they might mitigate the risks and maybe decide not to pursue claims. So it cannot simply be a binary, for or against ISDS, for or against the ECT. The point is to remain mindful of the point of the whole reform. I will hesitantly ask if there are any questions. I don't want to deprive anybody of any information that they might need on the spot. Yes, please.
Hello again. Really interesting lecture about renewables and fossil. But what you haven't mentioned, but I think it's really important for the business and the clients that we're representing, we are lawyers mainly here, is this new obligations that is coming really soon. It's called carbon tax, and everybody has to pay it. So each product who will be exported from this country needs to have certificates that producers use some of renewables or green energy inside their products. So we are facing now, which I can see by political status in the world, that I think fossil will arise in production because world needs more weapon, unfortunately. Military industry is growing and other things that you mentioned, but renewables are now like in station where they're like status quo, moving forward or not forward because of regulations and other issues they're facing. So, but imposing of carbon tax is coming. it's not stopping. So what do you think about that kind of differences and new obligation for the investors?
Thank you. And absolutely important element to the whole story is what happens to, not just to the renewables producers, but also the others and how they will be treated. Insofar as we're talking about existing fossil fuel players who are making investments now, and there will be investments, there will be CCGTs, there will be all sorts of fossil fuel powered plants. The merits of that are to be looked at on a case-by-case basis, of course, but there are examples like the situation in the Netherlands where coal plants were incentivized to invest in the Netherlands until a few years ago. And we know that there's a very significant lead time to return of investment, and then of course with public pressure those investments had to be scrapped recently in the Netherlands, and there were negotiations and there were treaties initiated against treaty disputes initiated against the Netherlands for similar but more radical solutions. Yes, we don't like fossil fuels, but at the end of the day, if we need the energy now and we're going to stimulate it, then there has to be some kind of respect for property rights. In the carbon tax field, Philip first mentioned, there's a first layer, at least on as far as treaties are concerned, that a large number of them, including the Energy Charter Treaty, will have tax carve-outs, and will only allow for claims to be brought insofar as they reach the level of expropriation. So the key disputes that come under those in that context are usually under FET, because you're not rendered inoperable. It's just that your margin is squeezed, and so that kind of case will be blocked. Certainly under Canadian, US treaties, and under the Energy Charter Treaty, and also Japanese treaties. I know this because the very tax clauses that you discussed in Spain, where they were in the Energy Charter Treaty, were first discussed in the UCOS case on which I worked. All this to say is there is also the element that we need to keep in mind is that there's a general view of this needs to be done. Investors are aware, even fossil fuel investors are aware that there will be measures squeezing them out, and so that will be taken into account in the decision on legitimate expectations, on the state's right to regulate, and so on. So it'll be a complex debate for sure. Anybody else?
I have two short questions. The first one, I mean, you describe situations playing within the European Union, and even the countries of the Western Balkans that are not EU member states are a member of the energy community, which obliges them to transpose the EU acquis. In this setting, is this additional layer of investment protection necessary at all? And the energy transition is going to come. It is driven by the EU with a lot of funds. Is there any downside to a state by exiting the ECT in the end? And my final third question is, the energy transition will come inevitably with additional regulation as well. And is arbitration the right forum to address issues of public policy and regulation, and especially also given the last judgment of the German Bundesgerichtshof, which says that it can review arbitral awards. It was in the context of competition, but it can review arbitral awards which touch on issues of public policy to a full extent on facts and law. So I leave it to you who wishes to address.
I think that the answer to the first part of the question really goes to whether private sector will be willing to invest without the protection, and I think that the answer is yes. Like, if you can make money, you will always invest. I think that there are two issues which we cannot forget about. So first is you can buy insurance against regulatory changes. It will simply mean that the investment will be more expensive. It will mean that then the revenue must be higher in order for the project to generate profit. So it will be simply more expensive if the investor is aware of the situation. Some of them will not. But I think that the downside of this path is that there will be a huge differentiation which will be growing with years between small and medium enterprises and multinationals. So multinationals will find ways of either finding some treaty protection by establishing a shell company somewhere, or buying the investment protection guarantee, or finding some kind of a contract with the government because they have the leverage to negotiate that. But then if you want to meet the energy transition, let's say the level which you are seeking as a state, probably you don't want to rely only on big players. And the small players will have a different level of protection. And the question is, do we want that the big multinationals are treated in a different way than the smaller entities? I think that for the last years, the answer was that we do not, and now the answer would be yes, we will allow that for the purposes of what is happening.
Philip, thanks. I think that's absolutely right, and obviously in the very simplified format of I have two jurisdictions, the same investment, same potential risks. If I have a BIT, I will invest in that one. That's true, but we also know that Brazil has been getting lots of investment without any BITs. We know that investments are going to Russia despite everything, and despite the fact that it's extremely difficult to get Russia to pay anything. This is true. As to whether arbitration is the right mode for resolving these issues, I live off arbitration, but I don't advocate it in every case, and I'm not sure it's the best thing now. But then we need to consider the alternatives. I don't think the EU is offering alternatives at the moment, despite their proclamations otherwise. I don't think that let's say the local courts here will be very popular either, and then there will be also the disparity of leverage that there will be between multinationals who will be able to pressure these countries sometimes, and then you will have the smaller players who will be stuck in a way. So I'm riffing off what Philip did in a way, but I think that's the reality.
Maybe if I can just add on one issue, is that arbitration is as good as arbitrators, and Urbaser against Argentina is often quoted in the criticism against the system, showing that it doesn't allow for counterclaims based on human rights to water, for example. This is the example which we often forget, that in the panel there were the former judges of the International Court of Justice. I don't imagine a person who has a more experience to judge on public international law. And simply the answer is that public international doesn't provide answers to everything. It isn't about international investment law, it's about public international law.
Thank you very much. Like I said, every single question, every single issue opens up many layers of discussion. We don't even want to go into the risk of what happens when multinationals actually are able to pull the leverage to have contracts as they wish and to have dispute resolution mechanisms as they wish, and all the other complexities, so we'll leave that for another day. Luckily, after our debate, we will turn again to our panelists here for their insights and comments about the views that will be expressed, only views, by our debaters after lunch.
So, welcome everybody back. We hope you enjoyed your lunch. Now we have something interactive for you, which we hope you will enjoy, which is a debate that's going to take place, moderated by Fahira Brodlia. And taking participation in this debate is Samira Sulejmanovic, who is a head of the Department for Bilateral Trade Relations in the Ministry of Foreign Trade and Economic Relations of Bosnia and Herzegovina. In her portfolio, she deals with overall bilateral trade and economic relations of the country, including negotiation and implementation of investment protection treaties, preferential trade agreements, and economic cooperation agreements. Even though originally a trade negotiator, the investment treaties became part of her job ever since she had taken over the department at the end of 2010. She has been very active in the international investment agreements reform process by advocating the need to rethink the international investment agreements as national policy objectives, working to establishing a critical level of awareness and pursuing joint action among countries in the Western Balkans region, and contributing to multilateral work and debate under the various international fora, primarily UNCTAD and UNCITAL. She has published a number of professional articles related to the most recent developments in investment and trade policies in the world, reflecting the position of Bosnia and Herzegovina, and she has co-authored studies, commentaries, and delivered lectures to postgraduate students on trade negotiations from the perspective of Bosnia and Herzegovina. She graduated in economics from the School of Economy and Business in the University of Sarajevo. And our next debate participant is Miriam Harwood. Miriam Harwood is a partner at Ketten Mutin Rosenman, LLP. Miriam is a recognized leader in international arbitration with decades of experience handling high-profile, high-stakes disputes in commercial and investment trade arbitrations, as well as litigation in U.S. courts. She has represented sovereign states, state-owned entities, and private corporations in a broad array of cases, including matters involving construction and infrastructural projects, renewable energy, telecommunications, mining, oil and gas projects, and other commercial disputes. Thank you. The floor is yours.
Thank you very much, Ayla. And we are doing this format for the first time. We are very thankful to our debaters for presenting views which do not necessarily represent their own. They had assigned positions in advance, nor the positions of their organization or anybody who they are affiliated with, including the ministry. But it's important to have a clash of opposing views before we can delve back into a discussion, just to see just how much goes into this. We are very careful about any conclusions. As Ilya noted earlier, we had this discussion in a panel last year. It was 1 week before the vote on the Energy Charter Treaty modernization. We were very optimistic that this year we would come back and continue to talk about how it's implemented, what it looks like, what are the new developments under the modernized ECT. We did not expect that the week later things would go pretty much downhill, and progressively so, for this treaty. So starting with the first vote, which was rejected, the EU and its member states did not approve. The EU Council could not come up with enough consensus for the approval of the modernized treaty. Then it stopped there when it comes to modernization. The EU went back and said, actually, the modernization is not good enough. The old treaty is unacceptable, so we should also withdraw from the old ECT. So they now initiated this movement to exit the treaty in a coordinated fashion, locking itself into the 20-year sunset clause that we mentioned. Many EU member states have already announced that they might soon initiate their withdrawal. Italy withdrew years ago. So it leaves us in a very historical and important moment, including for the Western Balkans. And it's for two main reasons. Number one, we are aspiring EU member states. The EU policies are becoming more and more clear on their rejection of such treaties and ISDS in general. And the countries in this region have different priorities at this moment and may not be able to rush into such decisions. On the other hand, whether we move towards reform immediately or with a delay, there is a high risk of disputes. We heard about the Spanish scenario, we heard about many other countries that were involved in this. The countries in our region cannot afford this exposure. They cannot afford a far smaller number of cases, let alone 50 at the same time. So with all this in mind, we will engage in a discussion just to see what considerations go into a potential withdrawal from this treaty, what it might bring, and then later on we can discuss with the audience as well what might be the best path forward. So maybe just to kick off the discussion, the framework issue, the biggest problem that the EU expressed with the ECT is that it's not compliant with the climate change mitigation objectives. They find it detrimental, it protects fossil fuels, we'll hear different arguments. So what are the climate change, Paris Agreement, and energy transition considerations that go into withdrawal? Maybe we can start with Samira.
Thank you, Fatira. I think it's really important. Thank you once again. Thank you all who remained in the second part of this conference. I think the debate is extremely important for everybody, but particularly important for the Western Balkan countries. I imagine we all can agree that one of the major reasons why the EU countries pronounced their coordinated withdrawal from the Energy Charter Treaty is something that nobody contested a great deal, and that is that the modernized text of the Energy Charter Treaty hasn't met the objectives set by the Paris Climate Agreement, and I imagine because of the Western Balkan countries' intention to join the EU at some point of time, we share basically the same objectives, and if it didn't meet the objectives for the EU, it certainly didn't meet the objectives for Bosnia and Herzegovina. On the contrary, as in the previous panel has been said, we are lagging behind seriously in establishing renewable energy sources, particularly in Bosnia and Herzegovina. So remaining in the treaty in which we do not meet these criteria and limit the policy options for the country in pursuing such objectives will certainly be more negative than positive. Just to give you a few facts about it is that even the report of the mitigation of climate change, the Intergovernmental Panel of Climate Change in its report in 2022 expressly stated that the ECT is designed to protect the interests of investors in energy projects from national policies, from national policies that could lead their assets to be stranded. So call for the reform of the ECT were amplified where foreign investors relied upon the ECT to institute proceedings against governments pursuing the phase out of coal production or nuclear energy for electricity supply. And for example, we have the Uniper versus Netherlands case and the case of Waterfall 2 versus Germany. As the IPCC suggested, such claims arguably were based upon considerations of fair treatment with regard to the allocation of costs in relation to energy transition. According to the European Commission, the protection granted to fossil fuels under the conditions described and for an unlimited period of time does not feed the EU objectives as defined in the European Green Deal, the REPower EU plan, or the climate law. To accelerate the shift away from fossil fuels and towards renewable energy, to achieve a greater energy independence, and to ensure EU energy security, to deliver the commitment to cut emissions by at least 55% by 2030, and to reach climate neutrality by 2050. Without further ado, and using many other arguments promoted by the scientific community, I think that the motion that the modernized text of the Energy Charter Treaty does not meet the objectives of the Paris Climate Agreement certainly stay. Thank you.
Thank you very much, Samira. And do we have an opposing view on this?
There you go. Thank you, Fahira. And first, I want to say that I'm in the uncomfortable position of taking the opposing view, and I normally represent states in investment treaty arbitration, so this is going to be a little bit of a reach for me, and don't hold anything I say against me. But in all honesty, when people say that the ECT has to be abrogated or that states should withdraw because it's incompatible with climate change initiatives and that it protects fossil fuels, those are kind of what we call the sound bites, the sort of the one-sentence explanations that are given for this movement to get rid of the ECT. And I find that very confusing because, as someone mentioned earlier today, There are dozens of cases that have been brought against Spain in particular, which were not brought under the ECT, which were not brought by fossil fuel producers, but by renewable energy producers. So to say that the ECT is bad and should be abrogated because it protects fossil fuel investors and stands in the way of climate change initiatives or renewable energy initiatives is just not correct. It sounds good. It sounds good from a public relations perspective because it may be a convenient political motto, in a sense, a slogan, that we as a state are doing everything we can to promote renewable energy and to move away from fossil fuels. But the ECT is not the problem. And getting rid of the ECT won't solve the problem because the ECT is only one treaty. It happens to be called the Energy Charter Treaty. So again, it has that public relations sort of slogan effect. But even if it didn't exist, there would be thousands of BITs, and even in the Western Balkan countries, dozens of BITs that these countries have entered into with capital exporting countries and energy producers from around the world who can still sue these governments if they took measures in the energy sector. BITs are not restricted to sectors. The Energy Charter Treaty is something that was designed to protect a particular sector, but even without it, BITs can do the job, and they can, and they have. So I think that there is a bit of a misdirected effort at the ECT. Not that I'm a drafter and love the ECT, but it is there's a lot of hoopla. There's a lot of basically energy and emotionalism, I think, directed at this treaty as sort of an emblem for the problems in ISDS generally. The fact that there's been a big backlash against investor-state dispute settlement mechanisms. But again, the ECT, and I guess for reasons that we will get to later, is not necessarily, it's going to solve it. Getting rid of it is not necessarily going to solve the problem that I think has everybody so upset.
And it's very interesting when we speak about emotion in treaty negotiations, but it has become such a whirlwind with all the media attention and the civil society attention on it. And it's important then to still be pragmatic about what would be the alternatives. So if we say something should be done about the ECT, whether we withdraw, whether we remain or modernize it, are there any other alternatives in this world without the ECT? Could energy investors be protected to a sufficient degree without it? Maybe Samira first again.
Well, we believe that leaving ECT would not hurt investors in the Western Balkan area because of a few reasons. First of all, majority of the treaties that bilateral investment treaties that the Western Balkan countries have concluded in their portfolio of BITs are those concluded with EU member states. So if we get rid of the ECT, the investors will be still protected by the relevant BIT. We have no exclusion of energy from those treaties, so the energy projects would be covered equally as ECT. We in Bosnia and Herzegovina, for example, in every energy-related cases have been sued based on the two legal acts. One is a bilateral investment treaty with the specific country, and the Energy Charter Treaty. So it's kind of a catch-all strategy from the investor's point. If we fail to do something under the BIT, then we do catch that under the ECT. We are talking about the existing old text of the ECT. Second, the majority of, I would say, the great part of the investments into the Western Balkan region, with the exception of Serbia, came from European Union countries. So again, the investors would remain protected in this part of the world. And for those who are not from the EU member states and are located in Serbia, it's important to know that Serbia is not a signatory to the Energy Charter Treaty. So basically they are not, either way, not protected by the Energy Charter Treaty, and no change would be seen in that regard. So I think the leave of the Energy Charter Treaty for the Western Balkan countries would not significantly change the level of protection for investors in the energy area.
Miriam, why can't we live without the ECT?
So here I would tend to agree with Samira to a degree, that because, as I said before, there are BITs that will protect investors. The Energy Charter Treaty isn't necessarily essential. It's true to the degree that Bosnia and Herzegovina or the Western Balkans countries have BITs with particular countries. But as you said, if that's generally concentrated with EU countries, then countries outside of the EU, which are potential sources of investment in the future, will be left out in the cold. Now, a few caveats there. First of all, you heard about the sunset clause. So we're talking very far into the future. So even if there was a withdrawal today, there would still be protection under the ECT for 20 years, at least for anyone who's already here. But the other downside, I think, in withdrawing from the ECT is that it sends a message to investors. And the message is that, regardless of the fact that foreign direct investment is needed, we are going to be curtailing, we're paring down, we're taking a protective, conservative position with respect to foreign investors, and we're not going to give you the kinds of protections that have existed up to now. And unfortunately, I think that the EU countries, capital exporting countries like, Spain, not Spain, so Germany and France and the UK, the Netherlands, they have the luxury of being in the position where they don't need the foreign direct investment, and they don't really care about the messages that they're giving out. They have other factors that balance against that: stability of their economies, strength of their economies, and that to follow their lead in a region that very much needs the foreign direct investment is sending a message that isn't necessarily appropriate to the circumstances. So that so we could parse through and say protections will continue to exist for 20 years, even if there's a withdrawal, and under BITs that currently exist. But messaging is important, and policies are important, and I think that it doesn't serve the interests of the region to send the wrong message.
On the messaging point, it's very pertinent for the transition to the next one. And I don't appreciate the violation of the rules. You agreeing with each other so early on, it's not planned, but obviously it's very difficult to stay within one niche. You do have to consider all the areas under this topic. But when it comes to consistency, the international legal framework rests on trust and compliance, pacta sunt servanda, in general contracts, but also especially in treaties, where states oblige themselves to also, provide protections to private entities to which they would not have to. And the EU, which has been founded on international treaties and supports this framework, has been iffy recently on their compliance and priority level of different instruments as such. So it's also important to note, the more you do this, the more you are inconsistent with the policy statements and implementation, you are also chipping away from the trust in the framework itself. But looking into, again, consistency, once we had the modernized proposal, the European Commission came out and said, literally, this is in compliance with our Paris Agreement goals. And then a few weeks later, we need to withdraw immediately, this is terrible. The modernization is not good enough. But let's look into the modernization itself. There have been some interventions into the most problematic substantive provisions that are most usually used for the investor claims. This would be fair and equitable treatment, indirect expropriation, other nuanced issues that keep recurring. So the modernized proposal actually gave some calibration to these provisions, seeking to, let's say, blunt them to a certain extent. So, Samira, would this be a mitigating factor? Is this something that is worth staying within the ECT for? Is it better than to adopt the modernization with these improvements? Or is the withdrawal still a better option?
Well, in my opinion, and I'll argument why I believe that this is still better to leave. It's less risky for us. It's less costly, if you ask me. But before I go to those arguments, just quickly to react to what Miriam said about messaging. I can also agree with her points to a certain degree. Unfortunately, in the country where I come from, we have been very bad with messaging. So that wouldn't be the worst message that we have been sending to the world. Second, in my experience working with the investors, of course it is important for them to have a certain level of protection. But this is not the only reason for them to decide whether to go and invest or not. Of course, somebody in the previous panel mentioned that a good cooperation and communication between investors and local governments would be best, because then we would better understand each other and maybe create policies which could serve both sides. So that's one of the options, that we could mitigate the absence of such treaty. And second, investors also have a margin of profit that they expect in investing. So, for example, in those very rare minerals that are just can be found at few places in the world, I don't think they very much care about the BIT. And also mentioned in the previous panel, the big companies can make the investment contracts with very tough investment arbitration clauses without BIT. So I think they would be fine if they find the interest to invest in the country. Back to your question, Fahira, yes, certain improvements have been done. The problem I see with improvements is the following. The negotiators, because we didn't participate even though we are the signatory, and don't ask me why, is that the definition of investor still remains quite wide, so it covers a lot. The fact clause has been modernized, the indirect expropriation also, ISDS chapter to a certain extent improved. But we don't know whether this will serve the purpose, because it can only be tested through case law. And we need to wait for the case law. And it cannot be one case to actually understand what is the real effect of a certain provision. So leaving the ECT for us would be like risk management. We would still have VITs, but at least we cannot be sued based on 2 or 3 different legal acts.
Miriam, what is your perspective?
So, I mean, I would say modernizing is the better alternative to withdrawal, and I say that with some conviction, for a lot of practical reasons. You know, number one, the 20-year sunset clause. There's not a lot that's going to be accomplished by withdrawing, except to send the message that is not necessarily the message that should be sent. And modernizing is really the only hope across the board, not just the ECT, but also investment treaties in general. There are those people who would like to just abrogate the entire ISDS system. I don't think that's going to happen, and I think that is too drastic anyway. It does serve a purpose. It is good to have a forum for investors and states to be able to hammer out their disputes that are not in the national courts, that, you know, are never going to be perceived as being objective and fair. So I think that ISDS as a system should remain. Modernizing it is necessary. I think everybody agrees on that. And unfortunately, it's harder. It's certainly harder to modernize and to get people to agree on the terms of modernization than just to say, oh, you know, throw this in the garbage. But it's not a responsible move to just say, throw it in the garbage, withdraw, forget about ISDS. It is unfortunately necessary for, and people in this room, people like us, are the ones who are at the forefront. It will fall on, especially on people like Samira, to be the ones at the front lines who say, okay, this is what we're going to agree to. That and what I like about messaging, actually, about modernizing is, in the Western Balkans, to say, when we're not going to just throw that away and walk away from these existing protections. We know what's happened. We have seen what's happened to developed countries and developing countries alike. And we want to mitigate against the abuses. We want to be sophisticated because we have the benefit of seeing the history since BITs came, just took over the world in the 1990s, and then the investor state cases took over, starting with the Argentina example and the Venezuela example and then the Spain example. There's a lot of history to learn from. So I think the wiser, smarter, more impressive move is to say, these are the areas that are problematic: vague FET clauses, undefined expropriation clauses, things like that. And we can only do the best that we can do. We can say, here's the way we can refine them, prevent abuses, and affirm or reaffirm our commitment to protecting investment in our countries, recognizing that is needed, and that protection is a good thing, but being smart and sophisticated and learning from history. And that message is the best message you can send, which is, we are on top of our game. We need the money, we respect you and your rights, but you have to respect us and our rights, and we all know what has happened before, and this is why we are changing the terms of our BIT or entering it into a new modernized ECT.
It's a very important point to make that basically policymakers right now have one foot in the issues of the moment, and all the pressures for policy, especially from the EU coming to the Western Balkans, they need to act now. At the same time, like Samira mentioned, we do not have any evidence that any of these reforms will work, including those that the EU is now introducing into their new treaties, including those that are promoted in different institutions or elsewhere. We don't know. Once you sit down in that conference room with that tribunal and you plead your case based on the new provisions, what will happen? So it's a very challenging position to be in. But Samira, I noticed that you had a note. Do you want to comment immediately?
Yeah, exactly. This is really important that I want to share with the audience, and just a food for thought. Something that we in the state administrations face, but the rest of the world doesn't know, or doesn't know very well, is the fact that there are two groups of states in this world. So there are capital exporting countries and capital importing countries. From the perspective of capital importing countries, the name of the game is totally different. So if you have two economically equally developed economies, then you have a playground which is pretty equal for them. I'll just give you an example, because negotiations between European Union, Canada, negotiations on TTIP between European Union and United States, which has been suspended. And you know that Germany had no problems with the ISDS whatsoever until it started being sued. Once the German government realized that they can actually also be sued, and not only being the claimant in the ISDS cases, then they started to have a problem with the ISDS. So the double sword for the countries in the Western Balkans is that we either are being pushed by the other contracting party, which is exerting pressure on the political levels, saying, we have a great investments for you, we just need you to sign the BIT exactly as we want you to sign, without having any barriers for what we want to achieve. And then we have this pressure from internal politics, in which the constant cycles of elections ask from our politicians, require from them to deliver on something. And what better could be than news on a new investment? The modernization of the Energy Charter Treaty meant that some states of the same economical level were negotiating with each other. And because of that, when you have more than two negotiators in a single process, you get at the end with something which is a common denominator. So this is not the best option. This is common denominator of what has been acceptable to everyone. So I imagine some countries, signatories of the Energy Charter Treaty, who were opposing totally some proposals and solutions advocated by the EU, actually reduced the original proposals to something that is like a little bit watered down. And then we just have to wait and see what is the effect of those provisions. That's what happened with the Arbitral Working Group 3, where you have 100 plus countries debating about different texts, and then you actually see that we end up with almost nothing. It's not totally nothing, because certain positions were so different that it was impossible to come to a common ground. And my last sentence on this, yesterday I attended the meeting over the OECD Track 2 on the specific provisions in the BITs, and two prominent professors were arguing about the potential effect of the qualified FET clause. I was happy to hear that, because that's what we negotiate now. And that's not linking it to the common international law, because we actually, and that was a fashion for a quite long time, because we don't know what the common international law is in specific case. So we basically leave it as an open air for the arbitration tribunal to see and decide. And if you have like a mixture of the two, we will probably have them deciding at some point of time that the common international law is to be followed instead of something else that we wanted to put in the treaty. So to cut the long story short, the modernization, the idea that was presented by Miriam is great, but from having that great idea and making it happen is a huge, long road, which obviously didn't happen, and that's why we should leave.
Thank you, Samira. We'll give an opportunity to Miriam to give her rebuttal to this before we move to the next point.
Thank you. So Samira's comments actually make me want to tell a long story, which is, and actually there are a lot of long stories on this topic, but it sort of brings you back to the history of BITs and how we got to this moment. Which is kind of a fascinating history, but perhaps everyone in the room knows, but the explosion of BITs in the 1990s, right, is generally attributed to the collapse of the Soviet Union, as is the ECT. The whole idea is that, we have a new economic order in a sense, and there's a focus on importing capital and developing economies, and a very pro-investor sort of state of mind in the 1990s. So all these countries go around and they start with these little BIT papers that are 5 pages or 6 pages, nobody's read them, and they start signing them by the thousands in the aggregate, or by the dozens, per country, and they become pretty much PR moments, right? It's you want that photo op, they call it a photographic opportunity, with the prime minister of one country signing, shaking the hand of the prime minister of the other country and signing the documents with the cameras flashing, and everything is great, except that 10 years later, all of these claims start. So that's kind of the historical backdrop, and I'll just tell you a very quick story. I represented Turkmenistan in a number of cases, and we had this recurring problem with this treaty that was entered into with Turkey. And when we went into the history of the execution of the treaty, it was basically Turkey. And it's interesting because you talk about capital exporting, capital importing, and in any duo, basically, in any couple, there could of countries, there could be the stronger party and the weaker party. In the case of the former Soviet republics in Central Asia, Turkey saw a huge opportunity. And Turkey had the upper hand. They had the potential investors who were going to go into those countries and do massive construction projects and infrastructure projects, which they did in the years to come. And it was Turkey who basically said, welcome to the free world. Here's a treaty for you to sign. It's called a bilateral investment treaty. Don't worry about anything in there. It just basically says you're going to protect investments. And, do we know that they actually pointed out, the clause where they can sue you directly in ICSID arbitration, nobody knew what that was. And it was done in such a hodgepodge manner. In the space of a week, basically, the Prime Minister of Turkey went to each country, Turkmenistan, Uzbekistan, Kyrgyzstan, Kazakhstan, and they basically gave them these documents, and they signed them, and nobody did the work, so that they're done in English, Russian, and then the native language of the country, except that nobody matched the translations, and they're equally authentic. So we have competing versions of the same treaty, which was a function of how quickly they were entered into and with such little thought. So not only were the provisions on a substantive level not understood by people, but even the details in terms of making them match were not attended to. So that's just one very vivid story, and it has cost the country millions of dollars to litigate what these provisions mean. In particular, it's something called a local court requirement, that you have to go to local courts for a year before you can bring international arbitration. So we brought the jurisdictional objection. We won it in one case. We lost it in another case. We had like a mid-range. It's mandatory in one case. Another tribunal looking at the identical provision said that it is not mandatory at all. The third one said, yeah, it's mandatory, but you know what? That's an admissibility issue. It's not jurisdictional, so we're going to let the case go. Happy to say we won on the merits in the other cases, but millions of dollars can be spent over these. Millions of dollars can be spent over these kind of details in treaties that people don't necessarily appreciate. So yes, the expression is the devil is in the details, that it's a lot of hard work to get the right language, and then to get your contracting party on a state level to agree to it. And yes, there isn't always equal bargaining power, depending on which country you are negotiating with. But on the other hand, this is not 1992 or 1995. And enough people know that there was a lot of messiness is a polite way of putting it, but it was nonsense what was happening in the 1990s with these BITs being flung around, and the kind of repercussions and very serious consequences for states, and that's just not going to be tolerated anymore. So that I think everyone, I would say, maybe it's optimistic, but I would say that at the risk of losing the ISDS mechanism globally in its totality, that there's a vested interest on both sides of the negotiating table, powerful countries and developing countries, to take a careful look at modernized terms and to reach agreement.
And the devil is in reading the treaty also. So speak about the right to regulate. Obviously now this is a reaction, this increased scrutiny is an obvious reaction to the previous disregard or lack of knowledge, or simply the position that these states were in. Both of you have made this very important point that not every state is attuned or able to influence, react to certain proposals as they come. So very, very important and illustrative points. Yeah.
I want to say one more thing, sorry. Samira mentioned that you don't know how these newly revised provisions are going to be interpreted by tribunals. But one thing that I can say is, based on my experience over in a few dozen investment treaty cases over the years, tribunals take it seriously when there is an interpretation agreement between states, or when there is a updated version of a treaty before them, and they know, and I think that they really do pay attention and respect the efforts to narrow obligations that are presented to them in new language. So I don't think we're going to have the situation that Argentina did after the financial crisis in 2001, where you had tribunals looking at the words fair and equitable treatment, having no precedents before them to judge that language by, and feeling that they had the freedom to put their own imprimatur on it and decide, well, personally, I think this wasn't fair. I don't think that that is going to be the approach of tribunals if they're presented with revised, updated treaties.
Thank you. So we do have one more point to address directly before we open for broader discussion, but this has been already so informative and elucidating. we do respect that now states are willing to look closer into provisions. And one of the unique features of the modernized proposal for the ECT was this flexibility mechanism. It said if the governments wish, they can exclude the protections for fossil fuel investments after 10 years of its enactment, which means if you desire to do so, you can. This is probably, again, a reaction to different positions of different states. We know in the Western Balkans, and Ilya mentioned it before, we are heavily reliant on fossil fuels. We need them, and we don't have the infrastructure yet to transition. So for our region, it might take longer, but there will be this built-in flexibility, which we don't see in other treaties, even the more recent ones, even those concluded by the EU. So this raises the question, does this improve the position of the ECT as a sector-specific treaty? Is it worth leaving it, or can states otherwise still accomplish the same goal of phasing out fossil fuels without risking too many disputes? Maybe Samira first.
I don't think I have a clear answer to that question because I don't understand myself how certain provisions functions of the modernized text of the ECT, and I'll tell you immediately why. As I mentioned before, not all of the signatories participated in negotiation. And at the end of the negotiation, it's only the EU, if I remember correctly, and the UK who actually secured a faster phasing out of the fossil fuels protection. For the rest of us, it's take it or leave it. That's one thing. Second, the right to regulate, which was introduced in the Energy Charter Treaty and also in our new BITs. If you ask me, I was wondering in the beginning why the state needs to put in an international treaty that it has right to regulate when it is its obligation to regulate in the public interest. So how come I need to state something that I'm supposed to do? Otherwise it would be an anarchy, right? But okay, and many people were arguing that we have no idea how effective that provision would be in practice. But one thing is for sure, and I had a short exchange of arguments a few weeks ago in Zagreb during another arbitration conference in which the young gentleman who was defending that position said that there are no scientific studies or evidence of regulating chill-out effect. And I said, there cannot be evidence of that because no state will issue a public statement that we actually stopped with regulation or changed the course of regulation because we were threatened or somehow warned by somebody that we are going to be sued under the BITs. But I'm absolutely sure, being a civil servant, that there is this chilling effect in regulatory space. To conclude, I am absolutely not sure that the provisions currently contained in the Energy Charter Treaty, the modernized text, actually provide enough flexibility for regulation, specifically for countries like countries in the Western Balkans.
So regulatory flexibility is kind of the name of the game, right? It's the core problem. And I think that what I thought was actually very interesting about the Spain cases is that all of those tribunals recognize the regulatory sovereign power of Spain to change its regulations in the renewable energy industry as it saw fit, but that wasn't the end of the story. It's like, yeah, but if you go too far and you hurt them too much, then it becomes unfair, and then you have to compensate. So it is a very difficult situation for states, and it's kind of difficult for investors too, I suppose. So definitely, and I take your point about having to state explicitly in a treaty that I have the right to regulate, because by the way, I'm the government, I'm the regulator. Of course, I have the right to regulate. But I'll tell you one more story. There is these rights on both sides, but they are not unlimited, essentially. I think that's the answer, and that they have to be moderated. So the story is, and I have represented 10 different states over the last nearly 20 years, so pick any of them, but I spoke to one person who was a deputy minister in some country somewhere, and this person was saying, I have the right to regulate. I am charged with regulating. And we had this situation with this dramatic change in the economics of the industry and the economy. And what I did was what I thought I had to do. And they can't complain. I have the power to do this. It was left to me to basically sit him down with a treaty and say, yes, of course you have the right to regulate. But there is also a treaty. And the treaty, which is binding on your government, gives the investor this ability to sue and say, okay, you do what you want, but if you go too far and you cross this line and you hurt me, this much, you have to pay me. You have to compensate me. And that was, I think that there was someone here who asked a question earlier about the unawareness, basically, of people who are in these positions of regulatory authority, not actually knowing what the consequences of their actions are, not knowing what international obligations are, not knowing the parameters in which they can function. And that is sort of an educational issue on both sides, where, like I had to tell this deputy minister, I'm sure you acted in good faith. Of course you did, and you assessed the situation, and you're a very smart person. But if a tribunal, they're saying you exceeded, sort of the realm of their expectations and economic fairness, et cetera, and damaged them. And if a tribunal agrees with them that you went just that too far, then there will be a liability finding and there will be a damages finding. And the shock, I felt so bad because the shock on this person's face was so genuine. And so it's like, I think somebody should have told the person before the regulations were enacted that you have to, it's almost like it's due diligence, knowing that there can be repercussions in international arbitration, okay, fine. But before you take action, get the advice, understand the significance, understand the players in your own market and sector who are going to be affected. Maybe even talk to them. Take their, input on this is a problem, this is what we need to do, get a buy-in. There are many ways of getting at it, but that is always going to be the most sensitive area, that regulatory space.
I mean, generally it's important to note that we cannot get rid of fossil fuels overnight. They don't disappear. These investors, some of them came in the 1980s, when this conversation was just an aspirational goal. Let's protect the environment in abstract. Let's always be responsible. But now we're facing a crisis, and we are trying to regulate old regimes in a progressive manner. So one challenging issue in this communication has definitely been exactly this. You need to understand, everything you're doing right now is right, but the consequences of what used to be still remain. And that's the biggest disbalance in the discourse. But the more of these open conversations that we have, the better it will be. And maybe the less siloed these different areas will be in general. And then you will not always need lawyers, as much as we love what we do, to translate these conversations. It should not be always discussed through ISDS. There are many other steps that can be taken otherwise. So thank you for raising these important points. We will come back to you for some final remarks, but we do have a few minutes to open up for comments or questions, and already we see a lot of interest in the room. So we can start right here, then we have Ilya in the back, then we have Philip. Anybody else, please make your presence known and we will accommodate. Thank you.
Thank you so much. My name is Jelena Todic. I'm a lawyer in Bredin Prat in Paris, a law firm that often represents states in these investor-state disputes. And for me, it is very refreshing to see a panel with someone who is actually negotiating these treaties and to hear the perspective of how state looks at these provisions and what attention is given to these details that we start assessing when we receive a dispute, and then we start thinking, okay, what did I think of in this moment, and how is this going to be differently interpreted in a case, or will it at all? My question is more general, because I would like to discuss very frequent noisy topic which happened during the COVID period about inserting exceptions in these BATs and the investor treaties. And there has been this talk of how this will allow for more regulatory space for these countries. However, we have seen, and that's what I found very insightful from Samira, where we need to have cases to actually see how this will be in any way impactful. But my question is for both of you, in general, how do you perceive this initiative of making carve-outs more present in these treaties, putting these exceptions which are more targeting specific industries, etc.? Do you believe this could be beneficial? What is the space for that in this ECT reform or generally? Thank you.
Thank you very much for those kind words. It really means a lot because I think, and I commented with Ilia during the lunch break, that I think there is a great gap in communication between governments and investors, and I think that should be changed because we fail to understand each other's perspective. It is no intention of states whatsoever to hurt investors or their investments. But as Miriam rightfully pointed, a majority of the policymakers, higher level, fail to understand what kind of obligation we actually take. And then you have this miscoordination vertically, so you have a local mayor believing that he has an absolute power of regulation in his small municipality and he doesn't care about any international obligations of the state because he cannot be bound in his understanding by the obligation taken by the state. To answer your question, what I learned from the arbitration community and many prominent professors is write everything into the treaty. So leave no space for somebody to dwell on what this should or should not be. That's what we did in our reform text, and we try to give as clear as possible guidance to the arbitral tribunal in case there is dispute, which is being resolved before international arbitration. What we mean, what we want, and what is not covered by the specific provisions, we definitely have this taxation completely carved out. So we explicitly say this agreement does not cover any taxation issue unless it's expropriation at some point. We also excluded a number of other issues. We clearly state that it's only post-establishment. So we don't leave some provision for somebody to read and maybe understand and maybe not. We say clearly, this agreement applies only to post-establishment, full stop. Or this agreement does not cover this, or in that case, it should be understood like that. And we make sure there is enough travaux préparatoires. That's what we learned. So Miriam is right, it's not 1992.
Very important.
We learned. I hope this answers your question.
Absolutely, thank you.
I'm a big fan of carve-outs, actually, because if you're worried about how tribunals are going to interpret, and I'm a practitioner, I don't do the negotiating side, but I've seen how tribunals and how parties plead their positions based on the language of a treaty. And it's really to everyone's benefit to have a clear, explicit treaty. Because you just waste everyone's time and money if you're arguing about ambiguities. And ambiguities result from lack of attention, lack of sophistication. And as I said, we have no excuse anymore to leave our treaties, to leave the treaties vague and unambiguous. And I think carve-outs are a great mechanism because again, seeing it as a practitioner, if a tribunal sees a treaty that says, like no claims shall be made for tax regulations, they're going to respect that. That's easy. They want bright lines. Bright lines are great for lawyers. We love them. So that's the carve-outs are great. That's the best thing. If you carve out a sector, they may not like it, but you're not going to even get the claim filed. If the claim gets filed, it's going to be the quick, 41.5 and exit or some, bad faith sort of thing, and you're going to deter the nonsense. You're going to really eliminate, pare down the universe of claims. in a way that is going to be very beneficial for the state, and at the end of the day, really better for investors as well, because who wants to waste their time and effort, pleading these things and rolling the dice? It's not really great for anybody. So yeah, precision is a wonderful thing.
Hi. I echo the words that it's quite insightful to have someone who's in the thick of it like Samira, and to hear your views of what you are facing now. And you are engaged in these kinds of activities while we're at the crossroads of what will happen with protection of investments in this region, what will happen with the protection of renewables, and so a really enjoyable discussion. One point that it occurred to me as we discuss the potential of scrapping entire systems or subsets of the system that we need to bear in mind at all stages is, why did we get here in the first place? Why did we set up this system in the first place? And I think a lot of people forget that. And the reason is, of course, because the tools that were available to resolve these disputes were inherently political. And when the tools are inherently political, like diplomatic protection or having to deal with states in their own courts, which will then be a political arm of the state, is that power prevails. And so the system was invented, among other things, to help transition from a power-based dispute resolution situation to a rules-based dispute resolution system. And what will happen if we scrap the ECT and other treaties is that we will return to this politics arena. And some previews of that we can see in the context of states who have decided not to comply with investment awards. So you can see what happens, how this political exchange will develop in that context. So for example, when as we know, Argentina didn't comply with many awards, the US withdrew trade benefits to Argentina. And I think even more interestingly, Spain, while it was in the midst of being sued by renewables investors, it was on the one and saying, no, the ECT is bad and treaties are bad. With its arm in the back, it was saying, let's deny credits to Argentina for what happened to Repsol in Argentina. All this to say is, I'm glad, as you're saying, Samira, that the view that's being taken by policymakers is significantly nuanced, and it's not losing sight of what will happen if this all goes away. And this is why, as I mentioned earlier, I am, and as Miriam has said, I'm a great believer in modernizing as opposed to scrapping. So I have no questions to ask, but just this comment to offer. And to thank you again for the very exciting discussion.
This one, okay. One argument, the last but not the least, as a conditional opening of negotiations with the EU, I imagine we need to align with the EU on their position sometimes, maybe not tomorrow, but in due course with their policy lines, even on the ECT. The good news for investors that there will be no coordinated withdrawal in the Western Balkans because we have, coordination is not among strengths in the Western Balkans, so, well, something good and something bad.
I just noted a few comments which I would like to make, and I try to speak always as an academic, not as a person who is supposed to be pro something, but I try to be as objective as possible, being an academic. And I always think about that dismantling a system is easy, but providing something else is much more difficult. And I'm keeping asking myself the question, would concluding a New York Convention, for example, from 1958, whether it would be possible nowadays, or concluding an exit convention, whether it would be possible nowadays. And I am afraid that no, because these were different times, and now such a huge project would simply not go ahead. And this is why I'm so afraid of alternative which we have, what if no arbitration, that we end up in local courts. And it's not always so frightening, but I am always keeping in mind the statistics proudly announced by the Polish State Treasury, General Counsel to the State Treasury, who are proud to announce that they win more or less 94% of the cases brought against state in domestic courts. And I am sure that if any law firm around the world would be even close to this number, it would be the most famous law firm in the world for having such a high success rate. So there is something wrong in domestic courts when you sue the state, so the person or the entity which pays the judges, right? So even if it is not intentional, there is something which is not always, it is something which is not always suited. And maybe another thought which I had when Miriam was commenting on this 90s, crazy 90s as pro-investor, at times I'm just wondering whether they were pro-investor or whether it was simply a time when everybody lived with faith in globalization. We don't have this faith anymore. I don't know if it's as easy to say pro-investor. It was simply different times, right? And about this right to regulate, which is always also commented, my thought is that I didn't see any award which would say that you don't have a right to regulate. So as you correctly say, states should not be obliged or should not feel obliged that they have to put it in the treaty. If they have to put it in the treaty, there is something wrong with the case law, probably. And this is my last comment, which I would like to make, is that at the end of the day, the facts win cases for me. And I mean, obviously, legal discussion, legal grounds, legal reasoning, all this is necessary. But at the end of the day, if there's some promise which was given and then it was not kept, then the question is who is responsible for that. And I think that at the end of the day, this really matters in terms of the outcome many times. At least this is what I have seen in deliberations, and that there are always different interpretations possible. So at the end of the day, it's about what happened and then finding something which is as just as possible in the believing of the arbitrator. So probably then, again, who is chosen, but it's factor dependent on the parties. So it's more maybe about the comments, but thank you very much for this wonderful discussion.
Thank you very much, Philip. So because our next intervention will be online, we have to be in time for the speaker. But Belma, if you can ask a question and then we can have closing remarks, we're still good, but just to note this.
Well, as a lawyer, attorney, I have one practical question, because we are discussing withdrawal or whether to withdraw from the treaty or not, and how that will affect the investors. I just wanted to ask how are current investors included in that conversation, or before withdrawal, or amending the treaty, and is there a possibility to arbitrate before any conflict or any dispute arise?
Well, it's the same everywhere. So the Bosnia-Herzegovina does not have investors, at least not investors that would be. I mean, we have few outside of Bosnia-Herzegovina. We are net importer of investments. So basically. These are the investors of other countries. In those big and powerful countries, the investor community certainly have a say, and they certainly have a communication with their negotiators, and that's how the policy is being drafted in other countries. To what extent they can be met depends on with whom the country negotiates, because if they negotiate, for example, the EU, if they negotiate with Japan, then they have offensive and defensive position. So they need also to defend themselves, because Japanese investors can come over to their market. It's not one-way street. If they negotiate with us, for example, they wouldn't probably care. They would take it as wide as possible. now that the MFN clause has been revised in the context that it does not allow the importation of clauses from other treaties. It is more safe to have these slight differences in approaches depending with what country you negotiate.
I think, in many countries, I can definitely speak about the United States, that when they were in the process of updating their model BIT, so the United States has a model BIT, and each new version is supposed to be the best version, and it's certainly supposed to reflect the history that preceded it and contain an effort to correct problems, to clarify ambiguities, to avoid, abuses, I guess, in the future. So I'm in the process of releasing a model BIT. There's a long period in which, and I can't tell you every step of the way, but where people get together and they come up with proposed terms, and then it's released for public comment. And public comment can come from anyone, can come from the investors, academics, lawyers, and it does, and it's a rather robust, or can be a rather robust discussion. Certainly in the EU, it's been the topic of discussion for years, and it's been very, I couldn't believe people were demonstrating about ISDS in Germany, years ago, where most of the world probably hadn't even heard of ISDS. But yes, there certainly is a mechanism by which investors can be part of that discussion. And I think that if they are part of the discussion, and if it's never going to be 100% of either party's positions, but if some of their concerns are reflected in whatever result comes out of that process, I think that they'll be more invested and feel more heard.
Question, and then you can wrap up and conclude immediately thereafter. So just 2-3 minutes left, but we do want to hear another interesting input, of course.
Just a short question for Samira. Thank you so much. Considering complexity of Bosnia and the level of the governments that are issuing certain rights or entering in agreements with the foreign investment, you're representing the ministry who are actually in negotiation with BITs and all those clauses. Which way actually they have a knowledge of their rights and responsibilities through the investments, because those investments are going deeply vertically with the local communities, cantonal abilities, federal, and then state not so many, because unfortunately the biggest issues like concessions are not sitting on a state level. So is there any communication on that matter? Because what I'm facing now and seeing in media, there is a lot of talking, pushing through certain NGOs or groups, recommending exiting state from the rights that they deliver, but nobody's talking about responsibilities or who will pay the damage.
That's a great question, thank you. Well, thanks to primarily GIZ and Fahira, ever since she took the role in the GIZ, in the project that is run by the GIZ, we have been done a lot. We are aware of the fact that major issues have been created by those lower level of administration, and it's not in Bosnia-Herzegovina, it's everywhere. We see the only way the communication and raising awareness. I cannot tell you that everybody was happy with our intention to tell them that they cannot literally do what they think they can or should do. But some of them have reacted, and I'll just give you a quick example how that resulted in a positive outcome. We had a letter from an Austrian investor in which they said they have a certain problem, and they also already used a specific provision from the BIT with Austria. They didn't really threaten, but the people in the ministry already used that. So whenever they see anything about BIT, they immediately send it to my department because, okay, we don't know, that's a problem, send it to Samira's department. And then we have a small collegium. The team is behind you there, the four of us, but I can tell you a great team, definitely. And then we discussed what to do. So we identify who are the players in this particular problem. And we wrote a letter to that institution. And we said, okay, guys, we received this letter. We don't know the facts, and we don't want to get into the facts, but we just want to tell you that there is a BIT with that country. And if they decide there is something wrong being done by the state's institutions to them, they have a right to challenge that before international arbitration. And we can also tell you that we are already in arbitration cases with this and this and this, and investors are requesting that much monetary compensation. So we get the call immediately, like in 3 days. Oh my God, let's have a meeting. And then we have a joint meeting with investors' representative and that institution, and I also came over. And we discussed what is the problem, and we resolved the problem without any further delay. My point was that that was the time when I actually realized that because of a lack of communication and understanding of a problem that investor encounters, we face potentially with arbitration that never would have happened. And to end with my answer, that's why we contemplated what would be the good way to proceed in that direction. We proposed to the Council of Ministers of Bosnia and Herzegovina a model for a mechanism of early detection and prevention of investment disputes. The Council of Ministers gave us a green light, and they say, okay, send us a regulation draft and we will proceed with that. So the next step is like creating a clear step line for the investor to know where to go and who to contact and whom to talk to when they have a problem. And it doesn't depend on whether I'm sitting in the department or somebody else. We all need to attend it. And if it still goes to arbitration, well, so be it. I don't know if it answers the question, but it's a difficult task, yeah.
Thank you all so much. We will have to leave it at this. We know every single panel ended too soon. We could have gone for hours. But thank you so much for your wonderful input. You still managed to find balance. You tried to be in opposing views, and yet there's so much to consider that it's important to be reasonable. We will not make promises about what we will address next year in this context. Let's hope we will get some better developments that will allow us to really discuss concrete developments, not in the abstract, what a modernization would mean, what a withdrawal would mean, to see actually how these mechanisms that states are implementing and how this higher level of awareness is being manifested in treaties, but also in practice of preventing and also resolving disputes. So with that, we do have 4 or 5 minutes of a break, so you can stretch your legs. We highly encourage you to stay for the last panel, which will discuss artificial intelligence in international arbitration, something we are just now getting accustomed to being a conversation. So we have some wonderful experts and interesting discussion ahead to close off this conference. So thank you all very much, and we'll continue soon.
So everybody, we will kindly ask you to get your attention back to our last panel for today, but certainly not the least. And for starters, I will again introduce our panelists and our moderator for the last panel. So the first panelist is Dmitry Evsev. He has a decade of experience acting as an arbitrator under leading institutional rules, and 2 decades of experience acting as an arbitrator counsel in some of the most high-profile investment treaty and commercial disputes in the world. He serves as a vice chair of the board of Stockholm Chamber of Commerce Arbitration Institute. Mr. Evsev is a member of the ICSID panel of arbitrator and has acted as an arbitrator and tribunal member in over a dozen cases under the LCIA, ICC, and under institutional rules. Another panelist that we are happy to have here today with us is Nasir Muftic. Nasir Muftic is an assistant professor at the Faculty of Law of the University of Sarajevo. He graduated from the Faculty of Law of the University of Sarajevo in 2016, obtained an LLM degree in the International Business Law from the Central European University in 2017, and his PhD at the University of Sarajevo in 2023. Nasir is experienced in the fields of media and telecommunications law, civil litigation, intellectual property law, commercial contract drafting, and regulatory compliance. His doctoral research is focused on the legal implications of artificial intelligence, on private rights with an emphasis on liability. Nasser studies the intersection between private rights and the technology. He has been a consultant in media law and digital policy projects organized by the Council of Europe, European Union, Bosnian and Herzegovinian government, and the Organization for Security and Cooperation in Europe. He advised the Council of Ministers of Bosnia and Herzegovina in the matters of the Council of Europe Committee on Artificial Intelligence work. And the third member of our panel is Jurgita Perkute. Jurgita Perkute is a partner at Keynote, a leading law firm based in Vienna for handling arbitration, litigation, and business crime matters. Jurgita specializes in international commercial and investment arbitration, where her experience spans over 15 years, covering a wide array of high-value and complex arbitration disputes, particularly in the Baltic region, Central, Eastern, and Northern Europe. While she advises clients from all industries, in recent years, her practice was especially focused on disputes arising out of engineering and construction projects, with contracts based on fitted conditions and contract for construction and others, and energy disputes including electricity, oil, gas exploration, transport, and supply agreements. Jurgita is regularly appointed to act as an arbitrator, and in this capacity has handled arbitrations under the arbitration rules of the International Chamber of Commerce, Arbitration Institute of Stockholm Chamber of Commerce, Vienna International Arbitral Center, Venus Court of Commercial Arbitration, and the Finnish Arbitration Institute. And our moderator for today is Armela Ramic, who is an attorney with over a decade of experience in practice. Her areas of expertise are civil proceedings, arbitration, commercial law, and public-private partnership. In addition, Armela specializes in representation of clients in court proceedings and arbitrations relating to construction contracts and FIDIC. As a president and co-founder of Association Arbitry, Armela possesses the knowledge and experience as the key legal aspects of the most complex international arbitration cases and practical application. Well, I'll leave the floor to you now.
Thank you, Ayla, for the kind introduction, and thank you all for staying for the last but not least panel. We can promise you very interesting discussion during this panel. Artificial intelligence has been used in international arbitration for quite some time now. Before the launch of ChatGPT, there seemed to be an implied consensus that neither soft law nor regulation on the use of AI in arbitration was required. AI tools appear to be considered as just one category of legal tech tools that parties and arbitrators are free to use without having to disclose such use to other parties in the arbitral tribunal. This panel will be opened by the presentation of Mr. Dmitry Evsev, who will provide us with unique insights into the current state of play and the first guidelines for AI in international arbitration developed by the Silicon Valley Mediation and Arbitration Center. Mr. Dmitry, can you hear us? I forgot to mention that Mr. Dmitry will join us online.
Pozdrav, drago mi je što na danu Sarajevske arbitraže govorim o važnoj temi umjetne inteligencije i tome kako je ona spremna transformirati pravnu praksu. Donedavno se činilo kao znanstvena fantastika da ćemo imati problema reći je li naš sugovornik u razgovoru čovjek ili stroj. Ali danas, svatko tko je koristio ChatGPT ili jedan od mnogih drugih inteligentnih chatbota, zna da su AI alati evoluirali, da razumiju ljudski jezik i odgovaraju na tečan i znalački način na mnoge teme. Audiovizualni alati također su napredovali do te mjere da je računalno generirane slike ili zvukove teško razlikovati od ljudskih kreacija. Potencijal ovih tehnologija, kako za produktivnu upotrebu, tako i za zlouporabu, je velik. I zato se ovaj razvoj ne može i ne smije zanemariti.
So, I have no idea what I just said, but I hope the rest of you do. I don't speak Croatian, I don't speak Bosnian, and this was my AI avatar talking that I trained this morning over 30 seconds of speaking, and you can have your own AI avatar that can speak any language, and you just type a message in any language and it will speak it in your voice, and it will speak it in a way that appears on video, like you were talking. Now, this is really neat, I promise. And what I wanted to talk to you about today is really the promise of AI technologies in the field of law. And in the field of law and arbitration, it's not so much the video and the audio tools, which are very impressive, but perhaps not as relevant to our practice. What is most relevant for our practice is something you may have heard of, which are called large language models. Large language models are really algorithms or computer programs that can interact in natural language, so they can interact with prompts that are typed or spoken, so people can type. If you use ChatGPT, you've used a large language model directly, or if you've used other types of chatbots that are connected with large language models, and I don't have to explain what they do, but essentially they've been trained on vast amounts of data from the internet and everywhere, and they have learned patterns of human language. They learn how to communicate not just a sequence of words, although ultimately that's all it is. They're communicating sequences of words, but they also have machines that basically learn the patterns behind the words. So things like grammar and semantic meaning and those types of things and concepts, although we don't really fully understand how they learned these patterns. Essentially what modern technology is involved is feeding large amounts of data into a computer program, and then the computer program itself tries to make sense of all the rules and meaning and everything that's being fed into it. So it's not a rule-based system the way previous automations and machine learning algorithms used to work, where you could clearly understand that somebody programmed it, that somebody gave it instructions saying, if this, then that. So these machines are much more complex, and they are less predictable in their output, and that makes them, in one sense, more useful, and in the other sense, less useful. So they're more useful because they can generate new text, they can generate drafts of documents based on documents they've seen before. They have a lot of world knowledge that has been essentially fed into them that they can reproduce in one form or another. And of course, that is quite clear as clear applications to all types of knowledge work. You can now basically feed a document into one of these AI models, and it will summarize the document for you. It will potentially find relevant portions of the document for you, and then it can potentially produce some other kind of document on the basis of that document. So that is one of the big uses for the field of law. Of course, we work with PDF documents, we work with documents in all types of formats, and this is exactly the type of format that these language models understand and process. So they can digest very large amounts of data. They can, and you give it, so basically you have to provide it with your documents, or you have to otherwise allow access to certain documents, and then it can answer not just based on a general world knowledge, but based on more specific knowledge that you want it to respond about. So that makes these tools particularly useful for legal documents, or documents that you are working with on your case, because again, you get answers that are more specific to you, and not just general answers. Now, ChatGPT and programs like that are very useful already for general knowledge. You can ask it questions about how something works, and it will tell you, give you things that are somewhat useful if you haven't done something before, if you're not particularly, you don't know anything about a particular area. It gives you a good general background, but it's not especially trained for the field of law, and it's certainly not trained for any particular legal system or any particular set of rules. So it's less useful as a product. It's basically a consumer product for the general public. Now, what I expect will be happening over the next months and years is there will be a variety of very specialized products developed for the legal sector, for specific areas of law, for specific tasks that we do every day as lawyers. And these tools, you basically be able to, at the click of a button, find relevant things in your file, help you prepare for, let's say, a meeting with a witness or with an expert. It can go through your file and find potentially relevant documents or even propose questions to ask during a hearing. It can potentially analyze submissions by one side or another. And of course, how well these tools work really depend on how well they are trained and what data they're trained on, and how they have been tuned or fine-tuned for the particular purpose that you're using these tools for. But the promise of these tools is really phenomenal, not just for the law, but really for any type of knowledge work, because essentially now you have a tool that can help you digest information, can help you, as we just saw, translate into any language, can help you potentially, can also translate, transcribe audio. And of course, we're familiar with some of these tools already from many years. Machine translation has existed for many years. Even automated audio transcription has existed for many years. Other types of AI tools have existed for many years, but they've been getting better. And they've been getting so good that oftentimes they exceed the level of what sort of an average translator or an average, stenographer can do in terms of recognizing human speech or translating it appropriately into another language. So I expect that these tools will be used more and more, hopefully to make everyone more efficient. And obviously that also raises a whole series of concerns, but I think others on the panel will speak more to that. What I wanted to focus on more is really the promise of these tools and the extent to which they can potentially simplify things that we do every day as lawyers. What I like to say is you basically never have to start from a blank page again when you're drafting something. So, of course, what the AI produces is usually just a starting point. Sometimes it's a good starting point, sometimes not so good starting point. And of course, you need to engage with the output that it produces and refine it, perhaps engage in a long exchange with the AI to get the kind of output that you want. There's a whole science now called prompt engineering, which is about how do you correctly ask the right questions of the AI so you get the answer in the format that you want, and how do you minimize hallucinations, which is a euphemism for essentially the AI making things up, which it does tend to do, and is a big problem. But again, you can reduce the amount of hallucination through various techniques. later on, and it will hallucinate less, and it can also give you citations for where it draws that information from so that you can then go and check it. And as lawyers, of course, we are trained to check our sources, to check our citations, to make sure that all the information is accurate. And that is not possible with ChatGPT, but that is possible with some of the new AI tools that are coming out and that are more targeted towards markets like law, where really mistakes can be costly and can cost, like the famous case in New York where a lawyer lost their law license for failing to check what the AI had, the cases that the AI suggested that he cited, and he cited cases that didn't exist. So there are a lot of dangers, and but I see these challenges are things that will be overcome with time. They will be overcome with better technology and more effort focused specifically on different areas of practice, including arbitration. What I think we may need to start worrying about soon is the AI getting too good and getting so good that people get lazy, and it's sort of like the drivers of some of these Tesla self-driving cars where they fall asleep at the wheel because they're so confident that the car's going to get them to where they're going. And I think we as lawyers will need to make sure we're not asleep at the wheel with these tools. But I do see the promise of it as being really transformational, and it is something that I'm working also as a founder of an AI tech startup. So hopefully we'll be hearing more about our products in the coming months. But thank you very much for the time to speak here today, and unfortunately I will not be able to hear you, but I will be online, and if there are places in the conversation where I can jump back in or answer any questions, I will be very happy to do so. And thank you again for inviting me to speak.
Thank you, Dimitri, for your presentation. As we could hear, the current application of AI in international arbitration and generally in our legal law practice includes tools used to identify relevant documents, generate and edit text, as well as translation, interpretation, transcription of the tools. And future application of AI in arbitration are virtually limitless, with many use cases in works. However, I do believe that we need to discuss about the risks when we're using these type of tools. So Jurgita, can you tell us more? What are the potential risks?
Thank you, Armela, very much for organizing us, and to the organizers generally for having me here. It's a pleasure to be first time in Sarajevo. It's a beautiful town with very rich culture. So going to our topic and to artificial intelligence, going to the topic of artificial intelligence and the risks, I think it's important first to probably define and understand what we are speaking about. And just a year ago, there was probably completely a dearth of any regulation on artificial intelligence, and now we see that there are efforts to regulate and to think about it also in the sphere of dispute resolution and in arbitration. And Dimitri did not mention that, but Silicon Valley Arbitration and Mediation Center in August 2023 issued the guidelines on the use of artificial intelligence in arbitration. And in the very first guideline, it in fact provides the definition of artificial intelligence. So what is it? in very broad terms, it's understood to be any computer system which is performing tasks which are normally associated with human cognition. Meaning it can understand language, it can understand semantic patterns, and it can generate certain outputs. So this is a very broad definition. It's a computer system which does something which we normally think only humans can do. And I think, as Dimitri rightly mentioned, we are using artificial intelligence in the life of arbitration quite a lot presently. Whereas using artificial intelligence when we are appointing arbitrators, because now there are tools where with one click of a button you can get to know with whom that person sat or did not sit, how law firms, when they were working together or not together. We use the tools for legal research. That's, I think, our everyday task. It can be used to draft document summaries and some parts of the briefs, to translate documents. We use it to organize exhibits, to make hyperlinked case files. It's being used for cost estimates. There are models developed where you can pretty well develop cost estimates, hearing arrangements, and document production. There are cases, for example, you have not thousands of documents, but 10,000s of documents. And if there is document production, everyone understands no human can read ever. So what happens in some cases, you define how the system will be asked what to find and what will be identified as relevant documents out of tens of thousands of them. So this is all very promising, and of course, especially in ChatGPT, becoming so much discussed. But these systems also do have limitations, and the limitations are serious. And I think we all need to think about them and to think how to overcome that. To start with, the first one is probably. I think it's necessary to understand that artificial intelligence systems are as good as the data provided to them is. So they have limitations into what has been fed into them. And I think a good example of that is for example, I checked myself into one of those systems, in terms of what data would it provide about me, in terms of relationship with other counsel and so on, and other people whom I know very well professionally. So the data which you would get from those systems, it's still distorted because it does not know everything. A lot of data is confidential. In commercial arbitration, it's a huge portion of data which is confidential. ICC, for example, started to publish their cases and announce who are their tribunals only from a certain moment. So, of course, the system gives you only what it knows, and it knows just a portion. So it would be a mistake to rely on the system and to think, okay, that's AI told me, that must be true. It's limited with the data it's being fed. So that's one thing. The second is that it's not very clear, as Dimitri mentioned, how the systems, especially large language models, are providing their output or what they generate. It's not, and it's based not on the legal reasoning, but on the probabilities and the algorithms work on the basis of probabilities. So of course they will give you an output, but they will not explain to you how they reached that output. There can be errors, and it has been tested so far. That's what is called hallucinations. So what the artificial intelligence is giving you as an output needs to be checked. So it still remains lawyers' task to screen what output you got, and it is the responsibility and probably still the liability if you put your signature below. And of course, confidentiality. Many of those systems, the data which if you feed your own data into it, one needs to check whether that data is not kept somewhere or could be leaked to even third parties. There are translation systems which are safer, which maybe cost something, but there are some which are not. And I think it reminds all of us about our primary duty of confidentiality, the duty we owe to our clients, to our parties, and that needs to be thought through and understood. So we need to know whether the data, if we put a certain data into the system, where it goes, and is it confidential, and can it be used potentially by any third party? I think this goes to the core of our obligations that we have in our profession, as counsel or as arbitrators, independent of that. So I think these would be the main areas of risks which can be seen. And of course, these guidelines which are being developed and also other regulations, they are thinking how to deal with them. And I think some solutions which are being proposed relate to a duty to disclose that AI was used, especially if it is used for the primary evidence or creation of the primary evidence of some pieces of evidence. And you know that the guidelines are also highlighting the duty to really know what you are using. Try to understand what kind of system you are using and what limitations and what security protection it has or it has not.
Thank you, Jurgita. Since you mentioned the Silicon Valley guidelines, I would like to refer to, we had, of course, a discussion about this topic early during the lunchtime, and I have discussed with Nasir the possibility of the EU regulation on tech law and generally EI. Do we have any type of regulation? What kind of regulation? And maybe we can even discuss about the definition of EI, since Jurgita mentioned the definition from the guidelines. Do we have any kind of definition on European level?
Let me turn on my microphone. Okay, great. First of all, again, thank you for having me here. It is really my pleasure to be here today and to discuss this very seldomly discussed topic in Bosnia, unfortunately. The question about legal definition is a tough one. Actually, one of the main points of debate in the European institutions, which are the Council of Europe and European Union, the European level institutions who are trying to develop pieces of regulation on artificial intelligence. One of the points of huge discussion, which still takes place, is the question of definition. There are various definitions in academic circles concerning this technology, and some of them are even universally accepted, if I may say. However, when it comes to legal definition, law requires clarity, it requires predictability, and in case of artificial intelligence, it is very hard to make such a definition. As far as I know, negotiations are still taking place. However, some definitions have been reached in case of AI Act. So far, what I think is the problematic part are the notions that are very ambiguous, such as the notion of autonomy. So what is autonomy? The ability of a particular piece of technology to first define an object, reach an object, to improve itself. So it is a very hard one. The second is who should set the goals. In some definitions, we can see that AI is defined as a piece of technology that operates on a goal set by humans. But it doesn't have to be like that necessarily. Third is there are various techniques of programming algorithms that are what we call AI. So those techniques are being developed over time, they change, they are being modified, improved over time, so it is very hard to catch all those techniques and the ones that are still not present today by a single definition. So these are the problems. When it comes to regulation of artificial intelligence, I would argue that we do have some regulation of artificial intelligence. This is a broadly discussed topic in even mainstream media today, because we all are aware of the, of course, large language models such as GPT, Google being an AI, it's similar, and we hear all the time that there is no law that deals with AI. That is, I argue, incorrect, and given at least in the continental Europe, the general or technology neutral nature of general rules, at least in private law. So Code Civil, BGB, even Bosnian law are designed to be technology neutral, to cope with the changes that technology brings, the changes that time brings, in order to be applied to various different situations. So I guess that we cannot really say there are no rules that could govern artificial intelligence. Of course, there are specific rules that should be applied only to artificial intelligence. This is, I believe, the reason why we have so many discussions around the world. Needless to say, major jurisdictions around the world, or the biggest ones, or the ones with the greatest capacities, human and resource-wise, different material resource-wise, are dealing with it. So currently, we're facing, at the moment, this is November, right, 2023, I think we can attest to various regulatory models that are being developed in different parts of the world. As Bosnia and all countries in Europe, we are, I believe, inevitably touched upon by the Brussels effect, which is the phenomenon that, in a nutshell, argues that whatever the EU does, other countries around the EU are trying to repeat, so some sort of soft power of the EU. However, there is also a formal requirement, as previous speaker said, of Bosnia and Herzegovina to align its law with the acquis. So I think what we will probably going to see in the next couple of years, especially from 2025 up to 2027, when the AI Act, the main artificial intelligence legislative instrument by the EU, but not the only one, when it is supposed to be to enter into force, hopefully, we will face, I believe, the process of implementation in Bosnia and Herzegovina and other Western Balkan countries.
Thank you, Nasir. I would like now to open the discussion with the audience. Does any of you use any kind of AI tool in your work? Also, this is a question for the panelists. You can open the discussion. Jurgita? Probably yes.
Thank you very much. I do. I think the ones which I mentioned at the very beginning, I think all those platforms and research tools, these are to some extent artificial intelligence tools, but I think they need to be used intelligently, in human intelligent way. Because I don't think they are now developed to the extent that you can rely on them exclusively. Mm-hmm. You still need to connect or collect data from different sources and to understand that it's limited. It can generate you a summary, but you still need to check and you still need to know whether the case is there or not, whether it says so or not. It's still your responsibility. And I think the tools are being developed very, very, very fast. And I know that the law firms, which have many offices, they invest into artificial intelligence tools who draw on the data from all of those offices. Mm-hmm. And then, of course, they tackle a number of risks which AI has, so confidentiality risks and all others. So I think we will see this being growing exponentially. And of course, I think we use, many of us, even probably without thinking too much, what we use. Probably we will use different types of AI tools in the future. More, generating us summaries, like for very, when arbitrator is writing procedural history, it's not so much reasoning, it's more to go through the process and to collect what has happened and to put it in one place. To some extent, AI can help to do that. It saves time. It's probably one click and you have something on what you can work. Mm-hmm. So I think that's what is coming. And for the question whether I use, yes, I do. I do check various tools when it comes to conflict check. I think it's part of our due diligence. The question is probably how you use that. Can you rely fully? My answer today is no.
Okay, thank you, Nasir.
Okay. Thank you. Well, I think, of course, I use AI as I believe most of us or all of us do, whether we know it or not. And I think this is also a problem, a legal one, not necessarily related to arbitration, which is we are not sure if we are using AI. So far, as far as I know, there's no a general requirement of companies in case of B2B or B2C relationships to disclose that they provide their services via artificial intelligence. And there are some exceptions, such as in case of personal data, but there is no general rule to whereby they would have to disclose this fact. I think that, of course, we will see the rules being developed over time, but I think there is a great threat to business community if we all tacitly agree to rely on artificial intelligence without telling each other, because it reminds me of Battle of Forms, where we have different forms that trying to compete to prevail over one another. So I think I'm afraid that in future we will have companies who are very wealthy, have many resources to employ their different AIs or the same AI to win certain, I'm not sure what, transaction of particular suitable conditions in a given relationship, etc. So I think fundamentally we need to be aware what is AI and when humans have interaction with artificial intelligence.
Thank you. When you mentioned that the huge problem could be in practice to disclose the fact that we're using AI tools, I'm interested in arbitration procedure. If some of the parties are using the AI tools, is it obligatory to disclose it to another party? Did you have any kind of cases or examples that you can provide us with, Jurgita?
I don't think there is presently any rule which would say you have to disclose or you don't have. The guidelines which came out in the draft form, they define certain situations where they suggest there would be an obligation and certain situations which suggest there would not be any obligation. So I think we cannot really generalize here because certain uses, they don't affect outcomes of the case and they don't need to be disclosed. But one can think of situations where I think it should be done. And these discussions, we have them in different contexts. And what guidelines are touching upon, for example, is that arbitrators should consider disclosing when they use AI as a search engine and they base their decision on that. I think it's a bit related to the discussion when the arbitral tribunal hears both parties but then decides that they will do a little investigation in the law and maybe find some other sources on which the parties have not relied. And what happens then, and what should happen then? In my world, what should happen if the tribunal has identified any other legal sources which they find helpful, this should be put on the table to both parties. Because otherwise the decision is based on something, because we are in commercial arbitration, on that no party has debated. I think similar is here. If the consulted tool is artificial intelligence, and it went so far that it affected the decision, it has to be disclosed. It's just the draft guidelines. I think we are just starting that discussion, but I think it shows that it could be used as a tool, and and it could be used as abuse, also false evidence. I think with these techniques, one can imagine that you are sitting in front of someone who does not exist. False evidence is not a new phenomenon. Does it happen often? I would think that case law shows not maybe so often, or we don't see so many examples. But what one can think that this can be used. So, of course, there are more fundamental questions like, that the artificial intelligence system should not be used to perpetuate biases. For example, I know that some credit institutions are using certain factors to define credit rate for a person. And if one of those factors is nationality, for example, I don't think it's really an appropriate tool to make a conclusion that if someone is from a certain country, then its credit rate is lower. It's not a causality. That's not what we should do in law. So yeah, that's my take on that. Thank you.
Can I just add a couple of words? First of all, I think that arbitration will be, so far as far as I understand, will be treated as high-risk application of arbitration by the current version of the AI Act, meaning that those who use artificial intelligence will have to certify, first of all, the system, and then to meet very vast set of duties. So it will be legal, but it will be highly regulated. Okay. So this is the idea currently. We're not sure since the document has not been. You want to add something on? Yes. Okay.
What kept to my mind, because you mentioned the EU regulation, which is being born probably a couple of years still will need to pass until we have one. There's one, I think, area where it is pretty clear to where regulators are going, and that area is that the decision-making itself remains with a human. AI cannot make the decision in terms of dispute resolution proceedings. So I think we had a lot of discussions in arbitration communities, thinking about robot judges sitting and deciding cases for us. I think that where the European regulation is going is to say clearly that the decision-making process remains with the arbitrator. And here, again, I see some similarities in other discussions which we are having presently. It's, for example, use of tribunal secretary. When we think about tribunal secretary, we also think to what extent it can or should contribute, and we always consider that the decision-making function is entrusted to the tribunal, not to the secretary. So the function should not go so far that it would undermine. So that the secretary's work product and function should not go so far that it would undermine decision-making of the tribunal. So I think similarly with AI, I think there is a clear line where EU wants to say clearly it's not going to be robots, at least not in the near future.
Thank you. Ayla, you have a question, and then Samira.
Yeah, I had a short question. Thank you both for giving us food for thought, as we heard from today earlier. All these topics are coming down to thinking about where the future is leading us. And when we are talking about inserting data, what got me thinking is if we are talking about human errors and machine making an error, where to draw the line? If the human who inserted the data should be the one who carries that burden, or is that the machine that processed that data liable for, let's say, giving false information or not doing as it should? So my question is to where to draw the line between humans making an error by using AI or AI on its own making certain errors. Thank you.
Nasser?
Thanks. Well, first, this is a policy choice. In 2017, the EU Parliament issued a resolution stating that the Commission should create a proposal whereby AI would be treated as a separate legal entity, meaning that it itself should be liable. However, the EU Parliament and later the EU Commission changed its opinion and said that the humans or companies who create, deploy, or use in different instances should be liable themselves. So I believe that machine itself should never be, I agree with that point. I believe that machines themselves should never be liable, and that errors caused by machines should not be treated as vis major, force majeure, unless explicitly stated by the parties, because otherwise we would shield either manufacturers who can create AI or users who can use in different ways AI from responsibility. In the long run, I think there will be no incentives to improve the AI itself or how the users use AI. So this is line economics type of argument that I agree with.
Thank you. Samira?
Thank you, first of all, for the speakers and the panel, and thank you for choosing this interesting topic for the panel, because I called me old-fashioned, but I am really cautious about AI use in arbitration, and I think it should be treated as such until we have it more regulated than it is. You just mentioned basically something that I wanted to say. In the Code of Arbitrator that has been agreed by the many countries in the Arbitral Working Group 3, we specifically said what's the role of the assistant. An assistant cannot write a first draft of the award in arbitration. So what's the difference of some program doing this? And I think that the issue is being taken too lightly, because the technology, of course, offers certain help, and it will inevitably be used sooner or later. I am just advocating for a more cautious approach until we know what's behind and what are the risks and how we mitigate those risks, such as confidentiality, specifically how we do that exactly. This is what happened with the digital assets, with the tokens, bitcoins, etc. We specifically excluded that from coverage in the investment treaty. If it is traded in an unregulated market, we don't want to protect something that we don't know what it is about. So we want to know who is regulating, how it is regulated, then we can talk about it. So it's more comment than actually a question to the panelists. Thank you.
Can I just add a couple of words? I think there are deeper problems. For instance, the problem of confidentiality. Well, we usually think of it in a traditional terms. However, given that AI is fed by data, there is a saying, garbage in, garbage out. It doesn't have to be. However, the AI operates on data, that is certain. And of course, we need data in order to train AI to perform better in future. Given the confidential nature of arbitration, especially commercial one, right? The question is, how do we provide data for training of AI if we are not allowed to provide data from arbitration itself? So I think we will be in this vicious circle unless we provide clear rules. One way is to anonymize or pseudonymize data, but again, we will have the context provided to the system, and we will have myriad of rules that we are probably not even aware of.
Thank you, Jurgita. Did you want to add something?
Yes, maybe just a couple of words. I think I fully agree in terms of decision making. It should and has to stay as it is. In the process, probably as a tool, it will be, can be, and it would be very efficient to use, especially for the monotonic tasks. There are risks, and just last week, US President issued a decree, 60 pages decree on the policy of the AI. I think it goes much, much broader into all fields of life, in fact. And the concern, precisely from the policy perspective, which I see in that decree, first of all, they want to understand what AI developers are doing. What is the algorithm behind? Because, as I said, if you attach a certain decision or certain credit rate or whatever aspect to something which has bias in itself, it's a problem. So that's one, what I see from the policy-making perspective as being considered. Second one is disclosures or marking certain parts which were produced by AI. And of course, confidentiality and security.
I have a question regarding the contracting the arbitration in arbitration clause. Should the as we may know that arbitral parties can choose language, can choose law, can choose anything they want in venue. If they choose to use a certain AI tool to reduce costs and to reduce the time spent arbitrating, would you consider that that would affect the mistakes made by AI would affect enforcement of arbitral award?
Thank you. I think my answer is not very, amusing. It depends. Because it depends, I think, on what would agree. And I think in the discussion we are having, we are generalizing too much. Certain aspects are clearly fine. I think, I don't know what the parties, what exactly reach an agreement on. Maybe they would agree that, which happens now every day, they would agree, we have a matter which has 1,000 documents. We all know nobody ever will read it in the course of the arbitral proceedings. And we agree that a sufficient search in that document base is if we put keywords so and so and then we have a result. I wouldn't see a problem with that. But if the agreement would go to fundamentals which you can attach to set aside grounds or refusal for enforcement, I think it could be, or one can imagine aspects which would make such a word non-enforceable, because it would touch on some fundamentals which are not acceptable. Either due process, if it is something, with false evidence or fraud or things like that, my imagination go as far as to see that it would touch upon the grounds which we now usually have for set aside. It could be public policy, it could be any due process grounds. So unfortunately, I think it depends.
Thank you. Thank you very much. It's a very interesting question, I have to note. Do we have any other questions from the audience? I can see that you're all very tired. We will finish very soon. I would like to wrap up at the moment. I will give a few minutes to our panelists for the closing remarks at the end, since we have talked a lot about the opportunities, about the risks, which include safety, transparency, non-discriminatory and environment principles. But I would like to, nevertheless, we do understand the risks, but I do believe that we have to take into the account the opportunities of the using tech tools. So I will give you now a few minutes for the closing remarks so we can wrap it up for today.
Thank you. Well, I think that the first conclusion should be that AI is here to stay, so we cannot erase it. We will have to deal with it. And we shouldn't fight it, which means that I come from academia, so in the world where I come from, copyright authorship is a big deal, and people are allergic to large language models. However, I don't think that, first of all, it is impossible to trace whether a piece of text that is carefully crafted is being drafted by a large language model. Even the company itself who created the ChatGPT cannot create a software that can with 100% certainty detect if the piece of text has been drafted by their own product. So I believe that we shouldn't fight it. What I also think is that we should recognize the parts of, well, AI regulation I think has its beginnings in the story, in the government use of artificial intelligence. The great media coverage began with the use of artificial intelligence by law enforcement, immigration offices, services sector around the world, and then moved to the big tech. There is no the regulation does not specifically focus B2B or B2C relations if those businesses are not too big. Now, of course, the AI will cover it, but this is not the main point, I believe. What I think we should do is that we should try to find, and we will probably do this inevitably in the next couple of years or a decade, to try to figure out a common set of basic rules concerning artificial intelligence. And the main one, because I don't know all the ones, but I think the main one should be that we should know when we have interaction with AI. And with that, I think I'll wrap up.
Thank you. Jurgita?
Thank you very much. I think many things were said. It's a useful tool. It could be an efficient tool. It needs to be used with caution. Of course, I think I sometimes feel now there is so much discussion about artificial intelligence, but in fact there is no clarity of some much less exciting things. When we had the advent of video hearings, I think we all saw that certain tribunal members had difficulties to deal with that. So with e-literacy as well as with case platforms, we have big still questions regarding electronic signatures to solve. Awards are being sent all over the world to get ink signatures, or it's very difficult we don't even have a tool to coordinate calendars, and it takes sometimes days, weeks to coordinate everyone. So I think it's useful to think about artificial intelligence. We have many concepts in place. Maybe we need to adapt them. Confidentiality is there. It always was there. Ethics is there. We all have codes. They don't speak about artificial intelligence. They speak in other terms, but they could be interpreted to encompass that. But also, we also should deal with questions which are probably less exciting, but which would make our lives more efficient and dispute resolution to work. So that would be my closing. Thank you very much.
Thank you. I would like to thank each of you. Dimitri, Nasir, and Jurgita, thank you very much for your time, for coming to 9th Sarajevo Arbitration Day. I do believe that this was a very fruitful discussion, and I do believe that we will continue to talk about this topic in the future. Now, I would like to give the floor to my colleague Fahira to give us the closing remarks for today's conference.
Thank you so much, Admila. I promise I have no further input. I promise I will not keep you here longer than 2 minutes. Just to wrap up this fantastic panel with a round of applause, please, for the panelists. And our multilingual online participant had to leave earlier, but he is fully available to everyone for questions that you can refer either to us, we can give you his email address, and he's more than happy to continue this discussion online and offline, hopefully in the future. I want to thank you all for sticking out for the whole day. We have taken you on quite a ride, from the history of arbitration to deep ECT and ISDS issues, and finally with some, hopefully, food for thought about the future of what processes could look like and what tools might be in our hands, hopefully for the best. With that, we wish you a wonderful afternoon and evening in Sarajevo. We hope to see you again next year. We have the official 10th anniversary, which will be an opportunity to reflect, to gather all of our participants from before, all our speakers, and to see just how far the discourse about international arbitration has come, from Bosnia and Herzegovina to the Western Balkans, hopefully then towards Europe. So thank you all, and I wish you a great evening.